Hello, everybody. Hi, Ava. Where you going, girl? I put the cat food dish over on the side over here, so she had to go check it out and see if there were any crumbs left. Yeah, baby. You don't need to forage for crumbs. You get treats. Had to make sure I had 3. She gets treats and I get treats. We have gifts. Oh, we have more gifts. This one is from Charlie. And I can smell it through the bag. It is from Sparrow's Coffee. I am so excited. It smells so good. I have not had coffee since I've been home from the hospital. Not kidding you. I cannot wait. This might have to be my first cup. Oh my gosh. Coffee at home made better. Oh, it says, love your first coffee or the next one's on us. High Five Blend. Coffee gives us feelings. It gives me feelings too. Charlie, thank you so much. It smells amazing. Oh my gosh. This one says, it's the Nostalgia series, and it says Air Fives from the Mitten State. Oh, it's from Michigan. Because making it out of bed is cause enough for celebration. Boy, is that not the truth? That's pretty much all I accomplish some days. High Five is our go-to for espresso with deep notes of chocolate, caramel, and a hint of fruit. My God, that smells so good. Oh, and it's got a little how you feeling emoji-gram on the side. Let's see, like right now I'm kind of like right here. My heart is melting. Oh my gosh. Hi, baby. Did you smell coffee too? Oh, Charlie, thank you so much. Oh, and then this is from Sweet Sea Rex. You know, some people have to pay hundreds of dollars for, their personal fashion wardrobe ensemble people. Me, I've got my mom. Oh my gosh, is this neat? Look at the pattern on this. That is nifty. And then this color, oh my gosh, this blue. You know what this is going to do to my eyes, Mom? That's so pretty. That is so pretty. I love this. I love this color. Blue really is my thing. Mom got me started on reds. I had never worn reds before, Mom. Ooh. Oh my. Oh, yes, yes, yes. I love it so much. I absolutely love it. Oh my goodness, it's beautiful. And it's so soft. I love this. Thank you so much. And then this one here. Let's see what this one looks like. in the gift note, it says, oh, it just says, enjoy your gift. I love you from Rexy. Okay, there we go. One just said, enjoy your gift. You know I will. Thank you so much. You guys make me feel so loved. Ooh, we have tissue paper. Okay. Okay. She's like, what's that? What's that? I wish you'd show your pretty face. Ooh, look at this. That's going to be neat. I like it. I like it a lot. Thank you so much. I cannot wait to try them on. But I know they're going to be beautiful. I already know they're going to fit. Hi, baby. How you doing? How you doing? Oh, hi, Jealous Ava. How you doing? How you doing? I have 2 hands. Yeah, yeah. So I can't do anything else for the rest of the stream. This is it. This is what you're getting. Okay, baby down. Baby down. Excuse me for just 1 second. Sorry. Laughing triggered airways. Oh, I'm getting kisses. You making me feel better? Are you making me feel better? Let's give you some of these. You really like these. You had your 3, and I filled your food dish. Quit playing. Quit playing with me. Peloton Pro! It's so good to see you in here. Hey, hey, hey. You tell Freddie T. Cat meow from me with an extra. Hello, C-Rex, my love. Hello, Manuel. I hope you had fun at the parade with the puppy. Hello, Nana Laura. Hello, Jerry Matthew Boyd. Hello, Charlie. I opened the present and I love it so much. It smells amazing. I cannot wait to try it. Hello, Donald Westerdale. Oh my gosh, thank you so much. That is so generous. I am so grateful. I love the little emoji panel on the side. That's so cute. That was me. Hello, Sherry B. Oh, hello, sweetie. I am so happy to see you. I hope you're feeling well. Hello, Hope. Oh, Jerry, thank you. Thank you so much. I appreciate that. Oh, honey, no. No, there's no such thing. I was actually, I know, like most women, they give 2 flips about, what they weigh and stuff. I don't care if y'all know. So when I went into the hospital, I was 267, which is actually like a lot lower than I was. When I first started streaming, I was like 285, 290-ish. And so I had lost quite a bit of weight. And now I'm on prednisone. You don't even have to eat on prednisone to gain weight. So yeah, let's hope that it doesn't completely backfire on me, because I really, really liked the fall that I was going down. Yeah. Oh well. Lost it once, I can lose it again, right? She has excellent taste. Yep. I I meow with Earl all the time. It it, I'm maybe slightly mentally unstable when it comes to my pets, but they're all I have to talk to. So Earl will come in and he'll meow at me and I'll meow back at him and he actually looks forward to it. I think because he continues to do it and he demands it in return. Hi, honey. You have 2 in a breath. Oh, they were actually. It was crappy. It was this uh from an instant machine. It was a Folgers where they put in these like liquid packs, and then it's just like this button you push and then this coffee syrup is mixed with hot water into a cup. Yeah, it's one of those machines. But see, it gives me heartburn. The coffee in the hospital gives me really bad heartburn. So yeah, I am so grateful to be home, and I haven't had coffee yet, um, just because I've been trying to focus on drinking as much water as possible, considering how dehydrated I was and that I'm still healing. But I cannot wait to have some of that. Hey, you stop. Hi, Earl. Well, it's actually Bandit, and kinda, but not really, sorta. I need to call the vet. I need to call the vet because it is not working as effectively as I think it should. I know she was off of it when um when I was in the hospital. So it is kind of like starting over again. But even before I went in, she she's either limp noodle kitty or aggressive kitty. There is no in between. And she has been, making messes on the floors again. I have steam away coming on Monday. But I'm gonna call the vet. I'm gonna say like either the dosage is not correct or the type of medication is not correct. One of the two. It's one of them. Speaking of which, I'm gonna give her her meds, because for her to just aggressively like hiss and like, you didn't see her, but her back end reared up like she was fighting mode with Earl there. For she would have done it. And Earl, he retaliates because he doesn't know any different. He just wants to say hi and play, and she wants to eat his face. My daughter is next semester. She's moving into a different apartment within her building. And I got yours, baby. Here. Come on, Earl. Earl. Come on. Yeah, I hear you. Why don't you come up here? Come on. Earl. Earl, come. Get your stick. So there's she's moving into a different apartment within her building, and she's going to be taking Earl, because Earl is her cat. I am just grandma, and I am just babysitting while she's in college. But you know, 4 cats is a lot. And it's her cat anyways. She wants him, and I don't really get to say no. I always told her I would never keep her cat from her. I wouldn't want anyone to do that to me. So as much as it's gonna hurt when she's ready to take him next year, or whenever they transition the apartments, then I'm gonna have to say goodbye. We'll have to do a special Earl tribute for the PAWFURM. Oh, I'm sure she does. And she was an only cat there. Hey, what? What? Oh, you won't eat it because Earl's in the room? You're gonna crouch in the corner like that? What is wrong with you? It secretly has your meds in it. Eat it. Yeah, I know the transition is a lot for her, but she's okay with Billy, and Tiny Kitten and her don't even seem to really interact a whole lot anymore now that Tiny Kitten's fixed. So it's really just down to her and Earl. And they're not friends. As much as I would like them to be, they're not friends. Look at him. He's staring her down. You need to just chill, buddy. You want some of these? Here. She's trying to make herself as small as she can in the tiny little corner over here. Oh, man. Hello, Ian Wilson, honey. Well, yeah, well, it works. Apparently, according to the vet, it metabolizes different in animals than it does in humans. So that's what it works on for us. Anti-seizure medicine, muscle relaxer, nerve, I don't want to say inhibitor, but it desensitizes the nerves and makes them non-reactive. So for cats, though, according to the vet, it does work as mood stabilizer and antidepressant. So I don't know. Apparently it's the same for dogs. That's what they use it for, is an antidepressant and mood stabilizer. Nope. Tried it. I have CBD kitty calming chews. She, aside from not even really liking to eat them, there's no effect. They don't do anything for her. I left the bottle in the kitchen. I'm trying something for myself. So I was looking up natural herbal remedies for lung inflammation. And I'm a firm believer in, like, garlic cures everything, but garlic just isn't cutting it. Let's, So, plus, garlic, gassy. I'd like to not be. So, I'll still eat my garlic. I love my garlic, but I needed more. So, anyways, there is an ancient remedy that has been used for treating lung inflammation, and it's a flower called mullein. So it's a I believe it grows in Florida, if I'm not mistaken. I might be wrong on that, but anyways, it's a yellow small flower that it's supposed to be used in teas and Do I want to know? Do I want to know? Oh, good. So yeah, I started it today. I ordered it, and let's hope. Yeah, mine are little little oil capsules. So yeah, the flowering plant, they typically use it as dried tea leaves. If not, then you can also take it as an oil, or take it like the oil in these gel capsules, which is what I have. I am too much of a texture person that I can do pills. I can do any kind of pills. Wait, that sounded bad. Um, but I can't do a lot of other things. Even like certain teas, when they leave like a film, or some of them just mess with me. Oh, good. I'm glad to know that it works, because I need something that does. Here, it's Mueillen. Let me hold on. I'll look it up. Mulllein. Let's go on a quick little field trip here. Okay. Mulllein is a woolly biennial plant, Verbascum thapsus, known for its tall flower stalks, and historically used in folk medicine for respiratory issues, digestive problems, and skin irritation, with potential antibacterial, anti-inflammatory, and antioxidant properties. The leaves and flowers can be brewed into tea or made into oils, while historical uses also include making dyes and as torches. Wow. Commonly found in roadsides, pastures, fields, and other disturbed areas, and grows wild in North America and Europe. So it's very beautiful. It's a very beautiful plant. Oh my goodness, is it so pretty? Oh, so pretty. Maybe I should just grow some around here, like grow it all over my yard. Oh, I'll have to, maybe one of the sides of my house that is nothing but catnip. I'll just start doing Mullene instead. But yeah, that's what it is. And I mean, you guys will know. You'll know if it's working. You see me. You see me every day, practically. Hello, PH Jess, honey. Eve, I don't understand any of that. I'm sorry. I don't understand a lick of it. What does that mean? Oh my. If only it wasn't Wisconsin. Hey, Earl's gone. Oh, he's staring from afar. You're never going to be okay, are you? You are never going to be okay, are you? You are just going to be my limp noodle kitty forever, always in my arms, always demanding love, which I don't mind that part. That's the best part. Why don't you please have your treats? Huh? Have your treat stick. Yeah. Put that there for you. Yes, Walmart does as well. Oh my gosh, it's so hot in here. I've got the AC cranked, but the humidity is off the charts. Thank God I'm on prednisone. Oh, I'm sorry. I am so sorry. I just bonked her in the noggin. I'm so sorry. Oh. I did not mean to do that. Oh, wow. That would be so neat to have it right there and be able to harvest it. Like, I don't know, maybe. Harvesting chamomile was so much work. I thought, oh yeah, I'll just grow chamomile and have chamomile tea and harvest it. And man, especially when dealing during aphid season and all the like cutting the heads off the stalks and everything, like man, maybe I'll just go out and pick a leaf every now and then and suck on it. Who knows? Oh, yeah, I got 2 of them right out back. A shot of that every day. Oh my. Oh my. Yeah, I use that in cooking. Yeah. I'll need extra virgin olive oil. Maybe it'll never mind. Meanie, who me? Why? What did I do? Oh. Okay. Now let's see. But I don't understand the comments until the context is like posted. It makes me look real dumb. Oh, now I eat a lot of butter. I do. I'm a Wisconsin girl. I eat a lot of butter. So I am not concerned that I'm not getting enough butter. And I don't mess with margarine. None of that turkey feed for me. No, it is butter. Margarine is like the only thing. It is molecules away from plastic, and it is the only food really that you can take a tub of margarine and take the lid off, put it in the back of a barn, and come back a year, 2 years later, it will be untouched by any living organism. Bugs will not eat it. Animals will not eat it. That tells me something. If even the roaches won't eat it, I'm not putting it in my body. It was originally designed to be a cheap turkey feed, but it kept killing all of the turkeys. And then they were like, well, we have all these thousands of gallons of this stuff. What are we going to do with it? It's like the consistency of a butter. And, oh, well, humans, they're not going to eat it in the same levels of what we were feeding the turkeys. So it won't kill people to eat it because they'll eat so much less of it. So let's just add some food coloring and call it that. We'll call it food. Yeah, it's toxic. Are you doing okay now over there, little missy? Gosh, you always look angry. All right, guys. So the show today is actually a couple of hours. It's 2 hearings. It is a well, it ain't. That's the problem. No. So it is a pro se in Judge Wolf's court, and I think you're really gonna love the punk at the end. It's my favorite part. I'll explain it after it happens. Let's have some fun with this one. Oh, by the way, just I caught bits and pieces of it when it was live, and I was thinking about it, but Judge Wolf's court needs so much editing. It needs a lot of audio work often and a lot of space gaps often. So I was hesitant on it, and then OSG messaged me and he's like, this would be really good for a live stream. Yes, it would. And then when I got into it, actually got into it, I realized there was another hearing that I had with the same defendant. So I had to then do that one. I couldn't stream the second one and not the first one, so had to put them together. But yeah, so this one is complimentary recommendation of OSG, our favorite squishy old man.
All right, we're going to take up a criminal matter that I need to address because we have a trial set for Friday. Upon the conclusion of this hearing on the criminal matter, then we'll come back to the Chancery docket. So we got Mr. Spratt, are you ready for Mr. Vaughn to be brought out? Maybe Ms. Duke wanted to take over as elbow counsel. So this is going to be the State of Tennessee versus Sherrick Markey Vaughn. All right, this is the State of Tennessee versus Sherrick Markey Vaughn. We have a number of, he has, I think, 4 different indictments. The defendant has filed a number of motions, some of which are addressing to different of those indictments. The one that I'm going to deal with, Mr. Vaughn, for your information, the only one I'm going to deal with this afternoon is the case that is set for trial on Friday, and that is the docket number 2022 CR 336. Am I correct, General, that that is the state's election to proceed?
Yes, Judge.
All right. So the case that's set for Friday is charge of driving on a revoked license, third offense, of resisting a stop, frisk, halt, or arrest or search, and then count 3 is retaliation for past actions. So, well, I don't know, I don't recall you being told specifically which one we're being tried on, but that is the one the state has elected to try on Friday. You have filed motions on that case, and that is the one motion that you filed is the motion that I'm going to address today. So it's your motion, and I will recite. All filed in one. Number one, there was a motion addressing all of the indictments that was filed back in March for a request for a bill of particulars. Is that a case that we need to address that motion? Beyond that, we also have your motion to quash or dismiss with prejudice suppression, and that's the one that is specifically addressing 2022 CR 336, which is the case that's set for trial on Friday. So let's start with that motion. It is your motion, Mr. Vaughn. If you want to address those issues, you can come to the podium and argue your motion.
Address one thing before we get into that, just because it will bring some clarity. The state was already planning to go ahead and dismiss count count 2 of this indictment, which is resisting arrest. State will continue to go to trial on count 1 and count 3, but that should shorten the argument some.
All right, so the state is moving to dismiss count 2.
Yes, Judge, which is the resisting arrest.
So count 1 is driving a revoked license, third offense, and count 3 is retaliation for past action.
Ooh, that is going to throw a wrench in everything this pro se knows, or thinks he knows.
Mr. Vaughn, do you understand that the state has moved to dismiss count 2 of this indictment? So you need to turn your microphone on there.
For fruits of the poisonous tree, they need to dismiss the rest of them because that was the reason I was even arrested to begin with.
Well, I am going to let you argue your motion, and
Your Honor, can I get a hand free so I can find my paperwork, please?
you may.
Your Honor, while he's doing that, may I address the court, there was a motion to quash the indictment in this case, and a bill of particulars motion, is that right?
There was a bill of particulars that was filed, a motion for a request for a bill of particulars filed March 27th of 24. And that contained, addressed 4 different indictment numbers, including the one for Friday, 336. The motion specifically addressing 336 is a motion to quash or dismiss with prejudice / suppression. And that was filed July the 7th of 2025.
All right, that's the one you're here to hear today, you said?
That is the motion that I'm going to hear today.
Okay, you said you want me to.
You may.
Your Honor, why wasn't I given notice of today's court date?
Number one, you filed these motions, and this is the first opportunity that we have to hear these motions or this motion prior to your trial date. I'm assuming you don't want your trial date continued from Friday, since you had filed a speedy trial motion.
Yeah, and I'm still stating the same thing on the record, that that is not what we were supposed to go to trial on. The last time I was here, it was for the case in Dixon over with Jennifer's mom. I forget the case number. There you have the case number. She didn't speak about going to trial on this one. The state changed it without giving notice again.
I'm sorry?
I mean, it seems like it's a hindrance to my defense when I don't know what we're going to trial for when I'm coming in here, and I'm told one thing and it's another thing when I get here, and I'm not even giving notice that I'm here today. Like, I wasn't expecting to be here until Friday, and I just filed 2 more motions that would have made it on time within the time limit that's required by the local rules of practice. I got them with me. I'm kind of caught off guard here today. The reason I'm trying to get
What are
understanding.
those motions addressing, Mr. Vaughn?
It was another to recruise Mr. Lee Spratt, and it was another to address these charges here today too, where there was some dismissals back when I first was arrested, and them dismissals still showed up on my Homeland Security report that it caused another arrest in another county. It was a motion to arrest judgment on that. That's yeah. So I feel like I'm getting caught off guard here.
Well, your motion to dismiss or quash was filed, and this case is going to trial on Friday, so I have to hear it before the trial. To not do so would basically mean that your case would have to be continued, or you'd have to waive your motion.
No, I'm in full understanding of that. Yeah.
I'm trying to give you an opportunity to have that heard and make a ruling on the record of it so that, you preserve the issue prior to the trial date on Friday.
Okay, do you also have a motion for chief evidence up there with you?
A motion for what?
For the state's evidence in chief?
I think there is a motion such that you described, but it is not addressing this indictment number.
I should have one for all of them, and including with this, is the state not required to respond to me? Because I've responded way before the state responded. She didn't even give me a response to this motion. I'm just filing this, and
The state does not have to respond to the motion until they come to court. They can then respond on an oral argument.
and then
you
I
do-
can have a response after that, correct?
Yeah, I'll give you a chance to respond after they do.
Okay.
But you do have a motion to preserve testimony or a motion to subpoena someone, and that is to subpoena Jennifer Dozier
Yes.
from Savannah, Tennessee. Was there a subpoena issued for Ms. Dozier in regards to his, he had requested that there would be a subpoena issued for Jennifer Dozier to make her testimony at the motion hearing date. All right, let's let you go ahead and argue the motions that you feel like are, there is a motion to preserve testimony or motion to subpoena that was filed again on July the 7th, and you've included all three of the case numbers on that.
You said which one was that, Your Honor?
The motion to preserve testimony or motion, and then slash motion to subpoena. Then you have a matter that you filed again on July the 7th called judicial notice. And this is where you're complaining about the discovery being delivered to the jail administrator rather than sent to you directly. And then we have the motion to quash or dismiss with prejudice.
That was Jennifer Dozier. Your Honor, can I go back to the table? Because all my paperwork's over there.
You can do that. We'll let microphone towards him so that we can make sure that he's picked up on the record. All right, did you see what you needed to see? All right. I want to deal with all of the issues that relate to 336 that are set forth. First one is the motion to preserve testimony or to subpoena this witness. So let's deal with that one first.
I believe that's fairly easy.
Push that base of that microphone towards it.
Can you hear me?
I can hear you.
Okay. And you're fine with me arguing from here, correct?
Yes.
Okay. I'm not seeing my motion. All right, hereby I, Cedric Vaughn, come to move the court to subpoena Jennifer Dozier. I have her phone number, which is listed. Her address is also listed, to preserve testimony in the above case and motions to dismiss. She has first knowledge on each pending case. I move the court to subpoena Jennifer Dozier and make testimony at the set motion hearing date. This is the motion I filed for you.
Okay, why do you need Jennifer Dozier subpoenaed?
Well, Jennifer Dozier is the mother of my children, and we were also living together. And every time I was arrested, she was present at every scene, and she can verify to my testimony of each case, like the illegal arrest, non-resistance, illegal search and seizure, twice and two separate. She can testify to every single thing that I'm stating.
All right, in regards to the case on Friday, which is basically a driving on a revoked license, third offense, and retaliation for past action, how does her testimony factor in on those two charges that we're dealing with on Friday?
On those two charges, I mean, I would say it would still tally in if we add back in the charge they're moving to dismiss, because like the motion states itself, that it'd be fruits of a poisonous tree, that they need to dismiss it because it was a illegal arrest from jump. I should have never been put in handcuffs or arrested or nothing. And she would testify I never resisted or anything. To take that one charge and just press it to the side and then keep the rest, it'd just be unlogical.
Well, I understand what you're saying, that she may have been present during some of the proceedings, but is she going to be able to testify about anything that has to do with whether or not you were driving or not driving a motor vehicle while your license was revoked?
I feel like that's a trick question, Your Honor.
Yeah,
you're probably trying to perjure me, aren't you?
It probably is a situation where you don't, because you're representing yourself. Well, obviously, we cannot get a subpoena issued and served on her at this point in time. Do you have any contact with her?
I do, and she would be a material witness, Your Honor.
And being a material witness, then you would be entitled to a continuance for the case on Friday if she's not present.
How long is this continuance, Your Honor? I'm so tired of these cases. I don't want it to be out months at a time again.
Let me run through this. Right now, do we have State versus James Wills? It is a go. State versus Hansard.
There might be another.
Is the Wills case going to go more than one day? So the Warren case is the one that I have the motion under advisement, but it is still set for trial. State versus Sarah Fuson is still go. So we could set Mr. Vaughn's case for the 25th, September 25th.
I'm trying to think, Your Honor. I also have Decatur coming up.
Decatur's on September the 30th. I just got it.
It's the 30th? Okay, that'll work.
Oh, yes. He has charges in other counties that he's going to trial for.
Is there any way we can also add in this other motion about getting heard about the Homeland Security stuff that was supposed to be dismissed?
Well, that really doesn't have any relation to what I'm doing today. What I want to do is deal with what I have to on this case, and then we'll set you another day for arguing the motions, because I just brought you in on a day when I'm supposed to be hearing chancery matters, which are not criminal, and I'm doing this in order to expedite the disposition of these motions. So what I'd like to do is to stick with the motions regarding this case and go from there. And if we're going to have to continue it anyway, then we can set all of the motions on, how big is the docket on the 22nd? About 49 pages?
And Judge, I will be here that morning, but I'm leaving at your lunch break.
Okay.
Could you be
Yeah.
here Friday morning?
What about, since we're not going to be able to go to trial, General, what about having the motions for Mr. Vaughn's case heard on Friday, the day we were going to try the case?
I can do that, Judge. I'm trying to work around. I've got several officers that are no longer in law enforcement. And so would you be looking at putting this for trial on the 25th?
We would be setting the case that you want to proceed on, 336, for trial on the 25th, what I'm trying to do. He has requested a subpoena to be issued from Ms. Dozier. He is entitled to have that witness subpoenaed. I don't find that there was one, even though I think it was probably just a series of motions that got filed and it just got overlooked. So I want to give him an opportunity to bring this witness in, to have her testify if he thinks it's relevant. So.
Judge, I think I should be able to move all of my witnesses around. I would ask if we can agree that if a witness is out of town or something else, that they could appear by Zoom to testify, which would keep us from having another continuance, but still have witnesses available. Because I can't stop right now and see if everyone I've got is available if we.
But again, this is only going to be on the 25th for this case 336.
I understand. I've got one officer that is working in Cleveland. I've got another that is self-employed. I've got to work around a couple of different things.
On the 26th, we have sentencing in the second-degree murder case of Curtis Day, correct? Sentencing, Hansard Rule 412 motions, State versus Sheets motion to dismiss, to suppress, Hicks and Long. Well, my only concern is trying to set this case for the 25th and hear the motions on Friday. Can we at least agree to set the motions on Friday?
Yes, Judge, I have one officer that is present today that will be unavailable on Friday. Could we go ahead and preserve his testimony today?
Yes. I'm going to move your motions to Friday to give a chance for you to get in touch with this young lady that you want to have brought in and see if she will come voluntarily. And I'll have the clerk go ahead and issue today a subpoena for her at the address that you've shown in your motion. But they may not be able to get it served on her, but if you'll contact her, she can be served with it if she'll voluntarily appear. And we can set your motions for Friday.
Yeah, that's frustrating, Your Honor. I mean, these motions been in. I mean, it makes no sense. I mean, she's prepared, but I ain't.
Well,
That's very frustrating.
resetting it to Friday is going to give you a chance to
I
prepare,
mean,
and you know which
it is,
ones.
but it ain't. It is, but it ain't. I mean, these motions been filed for 4 months. I mean, I don't understand why people just can't read the paperwork and do it.
Well, even by the record, they were filed July the 7th, so they're not been filed 4 months. Let me go ahead and just say that we're going to continue the motions to the 19th this Friday, and we're going to have the trial moved to the 25th. If, General, you may file your request to have a witness appear by Zoom according to the rule, and we'll have a hearing on that on Friday as well.
Well, if that's the case, Your Honor, can we go on ahead and get my other one added in too? I mean, because the reason I keep asking about this motion, this pertains to me in Decatur.
Well, let's just hear all your motions on Friday.
That sounds good.
Every case, Your Honor.
Pardon?
In every case.
On every case, we'll have every motion he's got.
That sounds great. That's great, Your Honor.
Your Honor, may I ask?
Count 2 is dismissed on the state's motions. They've acknowledged it.
Counting this one. Yeah, count it.
Yes, go ahead.
All right, thank you.
I'm
Your Honor.
going to go ahead and, I'm going to switch gears and go to Chancery for a few minutes, and then I'll come back to you. But I know you've got an officer that needs to be heard, and we'll try to do that as quickly as possible. Is it better for him to testify and preserve his testimony, or her, or to have them appear and testify by Zoom? Is there one way or the other?
I think his interaction that we need to preserve is relatively short. I think we can preserve it easily today and have you consider
All right,
it.
this would be just for the motion hearing, correct?
Yes, Judge.
All right. Well, give me a minute to see whether or not what they need to do, and we'll go from there. So I'm going to move to the Chancery docket for a moment, take up the estate of Richard Omar Myatt. Well, it is possession of cocaine, possession of a weapon by a convicted felon, possession of firearm during a dangerous felony, drug paraphernalia, violation of financial responsibility, unlawful removal of decals or plates, use of a handheld mobile assistant while driving, aggravated assault while displaying a weapon ×3, possession of a weapon by a convicted felon, reckless endangerment, evading arrest ×2, false imprisonment, reckless driving, vandalism, obedience to a traffic control device. So are those separate? I was going to say there's more than one indictment. Let's go ahead and issue that subpoena for this. It is Jennifer N. Dozier. You want to copy that and then hand it back to me? I'm going to step off, General, let them come get me as soon as Mr. Spratt is ready. What I'm understanding we're going to be doing today is just to let your officer testify to preserve his testimony for the purposes of the motions which are set to be heard on Friday. Okay, are we ready to proceed on Mr. Vaughn? Bring it up, Mr. Vaughn.
Judge, I need to update the court as to a procedural matter in this case.
Pull that microphone toward you a little bit.
Okay. Judge, I need to update the court as to a procedural matter in this case. Mr. Vaughn, in several of his motions, was asking about booking, and it occurred to me to double check something. So when this case was originally charged by warrant in June of 2022, the resisting and the driving on revoked were charged by warrant. The retaliation for past action was not added as a charge until grand jury, which was in October of 2022. Because we did not modify the bond, there was no new book-in at that point. I've not pulled up yet to see when he was arraigned, but he was later booked in on that charge February of 2024, when he was booked in on everything coming into custody altogether. But the booking may have been after the initial arraignment, which was what I wanted to alert the court.
According to the docket sheet, he was arraigned on November the 30th of 2022, and that the plea date was set for April 3rd of 2023, trial date of April 6th of 2023. And he had an attorney on November the 14th that filed a waiver of personal appearance by Mike Flanagan, his attorney at the time. All right, then we're ready to go forward on the preservation of testimony regarding the motion that Mr. Vaughn has filed.
Yes, Judge. Is there any need to rearraign him at this point?
That I'm aware of.
Okay.
The booking process is something that occurs at the jail for a person to be booked and processed according to the sheriff's department's records. This court speaks from its record, and this record is from the docket sheet, and the indictment that contained all three of those counts was arraigned, he was arraigned on that in November of 2022. Plea of not guilty to all of those was entered. He had a waiver of personal appearance also by his attorney at the time, So I do not find that there is any defect in the issue of the validity of his arraignment, because he had an attorney that waived the reading of the indictment, and this has never been an issue that's been raised up till now. So for that reason, the fact that he was or was not booked on count 3, he was booked on the original charges and when he was taken into custody, so.
Judge, I realize we are not arguing the full motion, but so that you may receive this testimony in a meaningful way, I would like to give this court a very brief, sort of factual summary of this case.
All right.
Judge, law enforcement came in contact with Mr. Vaughn while investigating a call out that Mr. Vaughn was the driver in a vehicle. In the vehicle was Miss Dozier, who you've heard about today, as well as their 2 children. The officer asked to speak to Mr. Vaughn separately, and he refused several times. Ultimately, she opened the door and escorted him out of the vehicle. That was the basis for the resisting charge that was originally the reason for arrest. It was later found out that his driving license was revoked and that charge was added since he was driving the vehicle. Now, once he was at the jail, he made several statements to law enforcement that are the basis for the retaliation for past action. And when we have the hearing, you will hear the bulk of those from Officer Javins. We do want to preserve the testimony of Lieutenant? No, Sergeant, I'm demoting you. Sergeant Stewart, because he will not be available on Friday. And so that he comes in after Mr. Vaughn has been arrested and is present in the jail and has already made some statements to Officer Javins, which you will get at a later date.
All right, you may call your witness. You may.
Clarifies to the matter the court ruled on.
You'll come to the podium.
Yes, sir. The arraignment, and Mr. Flanagan waived the arraignment. I just want to clarify for the record that his bond was revoked, I believe, on all these cases in July of 2024, I believe.
July 24th of 2024, the defendant failed to appear in court. Present was the DA and his attorney, Lee Spratt. Mr. Spratt spoke with the bondsman. The bondsman could not find the defendant, issued a capias and hold for a hearing. Final forfeiture was set for January 17th, 2025.
And the capias was served. I just want to make sure that, for the record, that he's never been booked on count 3, that in the event that we get to a point that he's going to get jail credits.
And I would only point out to you that when the indictment came forward with a 3rd count that he had not been booked on, there was no increase in the bond. So the bond that was revoked was the same amount that was put in place at the time he was arrested on counts 1 and 2. So there was no change in the bond. And I agree there might be an argument to be made about the booking process if in fact he had been arrested on a higher bond because of that 3rd count of the indictment.
Yes, sir. Thank you, Judge.
Then, General, you may call your witness.
State would call Sergeant Justin Stewart. Did I get it right? Sergeant.
Sergeant, if you'll come forward, we're going to put him over here.
Are you Sergeant Justin Stewart?
Yes, ma'am.
Would you spell your first and last name for the court reporter, please?
Yes, ma'am. First name Justin, Justin. Last name Stewart, Steward, David.
And Sergeant Stewart, were you employed by the Dixon Police Department on June 18th, 2022?
Yes, ma'am.
And during that evening, did you work a call involving the defendant, Sharik Vaughn?
Yes, ma'am.
And you continued working that shift afterwards?
Correct.
And you went to the jail for another call?
Yes.
Or after another call?
A warrant service, yes, ma'am.
And at the jail later on that night after his arrest, did you encounter Mr. Vaughn again?
Yes, ma'am.
Could you explain to the court what happened?
So at the time, I can't remember if I was a field training officer or a corporal, but either way, I had a recruit with me, Officer Floyd. We made an arrest later in the shift, and while we were at the jail to deal with our arrestee, jail staff pulled Mr. Vaughn, I believe, out of the holding cell he was in, and he was upset still at that point, agitated, and he made a statement, something to the effect of, I've got bullets for all of you, or enough bullets for all of you, et cetera. So I just mentioned to Officer Javens when I returned to the police department that was worth notating in her report, just in case in the future, if she were out in public, if you were to, attempt to follow up on those threats, the documentation would be there that they were made.
Nothing further, Judge.
Mr. Spratt or Mr. Vaughn, either of you have any questions for this witness? Come to the podium. And I would, again, Mr. Vaughn, I know you are pretty well acclimated to the law about a lot of things, but you must ask it in the form of a question.
Yes. Give me a second. How long ago was this case, Mr. Stewart?
2022, it's been a while.
2022. So you have full, you remember, have no problem remembering what happened?
Yes, as I said, me saying it, the phrase or the terminology of enough bullets for all of you, or names on bullets or things like that, I'm not 100%. I do recall it being concerning enough that I went back and told my officer to document it just in case you actually meant it and weren't just, upset in the moment, and may actually try something later.
So
Right.
that's what you're standing, you're sticking to it? Like,
100%.
you're fully remembering
Absolutely,
that?
yeah.
Do you have any video footage of this?
So we're working on that right now. We initially thought that my video footage was tied to Officer Javens' original case with you, with the traffic stop. And then it was learned recently that, no, in fact, my footage was not from me being present for her case. It was a separate case that we had afterward while Officer Javens wasn't at the jail.
So you don't have any footage?
Of my own body cam at that time, no.
Okay. Is there any jail footage that you know of?
I'm not sure. I know, as I said, Officer Floyd was there with me, and then, of course, some of the jail staff would have been present.
Okay, and you said they pulled me out of the cell, and I made these statements?
If I'm not mistaken, I know you were standing in the area in front of what is now Male Detox 2. They have a blue square on the wall to photograph people. I don't remember if they had just pulled you out, but I remember you being out of the cell in the open there when it was set.
Okay, I'll rest, Your Honor.
Yep.
Go
Have a
ahead.
moment, Your Honor.
Yeah, consult with your co-counsel. Yes.
I didn't catch your rank. Is it
Sergeant. Yes, sir.
Sergeant
That's
Stewart?
fine.
I'm
Yes,
sorry.
sir.
I always want to clarify. You said that he was pulled out of the cell and made the statement, "I got bullets for all y'all," right? And that's exactly how he said it?
Yes, sir.
Okay. So he never mentioned Officer Javens specifically then, did he?
I don't think he explicitly stated it was her. It was
Okay.
just law enforcement.
All right. So, well, did he say law enforcement?
The only other people in there would have been law enforcement, so I just logically, yes, sir, that's who he's talking about. All right.
But none of them are named in this indictment, correct?
I don't believe so.
Okay.
Anything else, General, for this witness?
No, Judge.
All right, thank you, sir. You may stand down.
Thank you.
For the purposes of the hearing today, we were preserving all of the other motions for Friday, and this was only to allow Sergeant Stewart to testify and preserve his testimony to be considered by the court at the hearing on Friday. So if there's nothing else, then we'll adjourn this case until Friday. Mr. That's a good question. I'll allow you to review the file and make that determination.
Your Honor, one more. Would you consider those motions that you probably haven't received yet, consider those as moot? I have, except the motion of indigency. You can keep that one. I just don't want to add no more time to the fast and speedy trial. So if we can't get them heard, I just want to consider them as moot.
If you have motions that you're going to file, make sure that Mr. Spratt assists you in filing them, and we'll have everything heard on Friday.
Wait, consider them moat? I've heard of considering them moot. I've not heard of considering a motion moot.
They're already considered filed by the rules, sir. Once they're put in a correctional facility now, they're considered as filed.
You want what?
Considering the Rule 49, they're already considered as filed. I'm just trying to get them considered as moot today.
Well, I'm not hearing anything else today to allow you to have an opportunity to prepare everything to be heard on Friday. Since the trial date is being moved, we're going to give you the whole day of Friday if necessary to hear your motions.
All right, thank you.
All right. Anything else before we adjourn? All right, and we stand adjourned. All right, we are here today on the State versus Sherrick Bond, and we have a number of motions that the defendant has filed pro se. Are we ready to proceed?
Yes, Judge, he's asking if he can have a hand free.
Do you have something you want to say?
He's asking if he can have one of his hands free to write.
Yes.
Judge, I will frankly say I am ready on most of the motions. Several of them require multiple witnesses, and in my attempt to get all of those who were not for the trial I was planning to try today, so they were not planning to be available. Some are in training, some are different places, so we may hit a motion that I have to ask the court to hear a different day.
Well, primarily, we have continued and reset his case that was set for trial today, and we have now set it for the 25th. So my question, I guess, would be, I want to run through the motions that I've identified in the file that I looked through this morning and make sure of what we are talking about and make sure there's nothing that we're overlooking. And then what I would suggest we do is we started the motion hearing with the testimony the other day on 336, indictment 336, which is the one you elected to go forward on. And I would say we conclude that hearing on that particular motion, and then we'll see where we are on the other motions and hopefully be able to take care of many of them as we can. So the motions that I'm showing by my review of the file is a request for a criminal record for the defendant requested on April the 21st of 2025, a copy of his own criminal record. That would normally be supplied in discovery. Has that been supplied to the defendant?
Yes, I have received it, Your Honor.
All right.
Can you hear me?
Is that microphone? All right, thank you. So that one has been complied with. All right. Then on April the 21st of 2025, you had requested to remove your elbow counsel or your counsel, Mr. Spratt, and I think we relegated him to the role of elbow counsel. And the other day, if my understanding is you're okay with him continuing as the elbow counsel, you will be representing yourself, correct?
Yes, sir, I will. And you can strike that motion as moot.
All right. On May the 1st of 2025, there were motions for discovery. Has the issue about discovery, I know you've had some issues regarding the delivery of that. The problem lies in the jail has certain restrictions on what can be or cannot be produced, and sometimes the electronic discovery that the district attorney's office utilizes makes it difficult for inmates at the jail to be able to receive and review that information. Where are we on the discovery?
I've received all discovery, Your Honor. They were printed out and delivered to me. Mailed to me as you requested.
Move that microphone a little bit closer to you. Just move up and slide it. You've received all discovery except for what?
No, I've received all discovery.
All right. Then we'll show that has been complied with. On May the 9th of 2025, there was a request for a recusal of the master clerk. My understanding was that was based on some objections you had. I have denied that motion. On May the 9th, you had a motion for recusal of the court reporter, and I believe I have previously denied that as well and would deny it again if it were renewed. On May the 9th, there's a request for a copy of records and file. A copy of the entire court file and record is what I'm understanding. Is that an issue that we need to address?
I believe that the discovery, I think we actually addressed that already too. Unless there's something that I'm not aware of that's been filed into the case.
I believe that everything that would have been relevant has been supplied to you. We'll go ahead and do that. On July the 7th of 2025, you had a motion to preserve testimony and a motion to subpoena the witness that you wanted, and I had instructed the clerk to issue that subpoena that day. And my understanding was she contacted the Sheriff's Department in Hardin County, Tennessee, where she lived.
She's present today.
All right, and so she is here.
Judge, I don't know if there was a second subpoena issued for trial on the 25th, so she may need to be instructed to be
We need to go
under-
ahead and issue a subpoena for her to be here for trial on the 25th.
And that can be
All
served
right.
today while she's here.
So she is present.
Yes, Judge. I have asked her, when she came in this morning, I asked her to wait outside in the witness room.
Just make sure that she understands she's not to leave and that she is under a subpoena. On July the 7th, you filed something called judicial notice. Does not appear to me that that's anything that we need to argue. But then on July the 7th, you also filed a motion to quash or dismiss the indictments against you, and I think that is where we are today. So the motion to dismiss or quash, General, you had started putting on your proof. Are you ready to proceed?
1 second, Your Honor.
Any other motions that I'm not familiar with? You had indicated you were going to file some additional motions.
Yes, sir, they're filed. I believe the state has a copy of it.
Do you have any additional motions? General, if you will allow me to have a copy made of the motions, they are not contained within any of the files that I have.
Judge, the motion that we're arguing, the motion to disquash, dismiss, I don't have the new motions. But I have a copy of the motion to quash, dismiss with prejudice suppression.
Well, I have that.
Okay.
Copy of them right here if you want to get another copy.
Let me just look at it. I don't show that these copies are actually have been marked filed.
I have a certificate of service somewhere. They're not, they were filed in the mail. Rule 49 requires that, that states that they're filed once they reach the incarceration mail of the facility I'm at. They've been filed since, I want to say, last Friday.
All right, I have two motions in my hands. Well, one motion and one something else. First motion is a motion of indigency where Mr. Vaughn is alleging that he is indigent and therefore he's asking that the court find him to be indigent. Second is a document he has styled arrest of judgment. And it says, I, Sheriff Vaughn, come before the courts of Dixon County that the foregoing is true and to the best of my knowledge under the penalty of perjury on April the 7th of 2024, dated the attached document you can see I have on my record of driving on suspended charge for failure to appear out of this court labeled Exhibit A. This failure to appear came out of this court, a charge that was dismissed. I pray that this error is amended and the proof of amendment be promptly provided to me. And I'm not sure exactly how that relates to what we're dealing with today, but
That pertains to one of the charging instruments out of this court, sir. On this
Right.
case right here.
Mr. Kenny, can I have you to make a copy of those, please? All right, I'll make copies for myself and for the state, and then we'll go ahead and start with the hearing on the motions.
Okay. Your Honor, I got one more for you.
Miss-
It's a judicial notice for you.
All right, this is styled a judicial notice / notice of objection to the state's failure to file a written response to the motion to suppress. I, Sheriff Vaughn, hereby come before the courts of Dixon County Circuit Courts affirming that the foregoing is true and the best of my knowledge and freely given under the penalties of perjury. And then you go ahead and cite under Rule 47 of the Rule 49 of the Rules of Criminal Procedure that a response is to be written unless otherwise permitted by the courts. And you're asserting that no written response has been filed by the state as of the date of this notice. No oral response was authorized by the court. In the absence of a written response, prejudices the defendant's ability to prepare for the hearing and address the state's argument. Therefore, you as a defendant requested the compliance of the service and filings of pleadings required under Rule 49, and that C, it shall be stricken from the record and Rule 47, take notice of the state's noncompliance.
Why do they think that it's a requirement for them to receive an answer? The world does not revolve around you, sir. And the judge literally at the last hearing explained it to you. They're not required to file a written response. They can show up to court and argue their response as an oral argument to your motion. Like, sorry that your mommy told you you were special all your life. She lied.
Limiting the state's argument to those properly raised in writing, grant any other relief. Would you take that to Ms. McKinney and have her make a copy? So, any other motions?
Yes, you didn't bring up one. I'm not finding a copy of it myself, but I filed and requested for evidence in chief probably back in May.
I just sent Officer Moyer, he has another motion for you to copy.
As a part of the discussion.
Again, I don't know what you're referring to, a motion for arrest. What is it?
It's a motion for arrest of judgment. From my understanding of what I've read, arrest of judgment is really there's no proceeding forward until this is resolved.
When did you file it?
This was filed, oh yeah, the certificate of proof of service is on the back. This was filed on the 15th of August.
This year?
Yes, sir.
Judge, I think this is actually going to apply to a different docket number, and that may help. Mr. Vaughn had an FTA that was dismissed. Is that the one that you're meaning to file this on?
Yes.
Okay.
I think that's his copy.
Judge, if I may suggest to Mr. Vaughn that this actually should be filed in 2024, CR 18. That is a case that was before your honor. It was an FTA. From his filings, the state recognized that his FTA was not willful, and I dismissed it. You heard that. And so that's the case that he's looking at because he's saying it's still showing up on his criminal history.
Well, he would have to have it expunged. He'd have to file a motion to have it expunged if it's been dismissed. So the motion for arrest of judgment, Mr. Vaughn, has already, that matter has already been resolved by my dismissal of the case. And if you wish to have it expunged, you can file a motion for expungement.
Okay. Would the courts take notice to that wasn't properly dismissed or destruction of the record like it was supposed to?
It is not an automatic that a case being dismissed is destroyed or expunged. You must file, any defendant who has a case that is dismissed has the right, if they choose, to file a motion to expunge their record. And when you do that, I will sign an order expunging the record, but it's not an automatic thing. So.
Okay, Your Honor. I have some questions for you too before we start too. Monday, we came in here and from my understanding, you told me any more motions that need to be filed into this court need to be filed through my elbow counsel. That is a prejudice to me defending myself as a pro se litigant. If that's still the order that stands in this court, then that is denying me access to the record, Your Honor.
What are you saying?
That is denying me access to.
What are you objecting to?
I'm objecting to the order that you gave on Monday that any more motions that need to be filed through my elbow counsel.
I don't recall making such an order, Mr. Vaughn. I recall suggesting that you get with Mr. Spratt and that you and he, or that he assists you in doing that, but I never ordered that you had to file it through him.
Okay, then it's understood then.
Anything else? Microphone, please.
I can't seem to locate the order that appoints me as elbow counsel on the online system. So before we leave today, I need to get a copy of that. I don't see it in the.
If the order hasn't been actually typewritten, I saw an order that appointed you as counsel, and I think he had filed a motion to have you removed, and I amended the order to just make you elbow counsel, is what I recall. So,
I recall it being elbow counsel from the start,
and
but,
it may be.
but either way, I kind of did want to clarify that for purposes of
Your
the,
role in this is to advise and consult with Mr. Vaughn, but he is representing himself.
yes, sir.
Are we now ready to proceed on the 336 motion?
Excuse me, Your Honor, you said 336? I mean, 336?
336, indictment 336 is the one that the state has elected to proceed on trial next week.
Oh, I don't know if we'll ever be ready, Your Honor. I mean, this has been going on for quite a while, with the judge just trying to get to the hearing, to the actual hearing.
And so we're going to address those motions first.
Can we move to the judicial notice objection? Notice of objection for that case is pertaining to that case too, Your Honor.
Are you saying the notice of objection to the state's failure to file a written response? Is that it?
Yes, sir.
All right, your motion, you may argue it.
I'm sorry, Your Honor. I'm requesting for the courts through this motion that any improperly filed motions, any properly invited witnesses to this case and any testimony that should be taken into this case be stricken from the record or not granted due to the fact that I was not given proper notice to prepare a defense. If you see any other justice to be served, I suggest you go ahead and make a ruling on it.
All right, I'm prepared to make a ruling on it. Rule 47 of the Tennessee Rules of Criminal Procedure, which is what you have filed your motion arguing under the authority pursuant to Rule 47 and Rule 49 of the Tennessee Rules of Criminal Procedure, that you're arguing that the state was required by law to file an answer to your, in writing to your motion, and that if the failure to do so means that they could not present any proof. However, Rule 47 of the Rules of Criminal Procedure provides the following. A, in general, a party applying to the court for an order shall do so by motion. B, form of motion. A motion except for one made during a trial or a hearing shall be in writing unless the court permits it to be made orally. That's the motion. C, content of motion. A motion shall state, 1, with particularity, the grounds on which it is made, and 2, the relief order sought. D, affidavit. A motion may be supported by an affidavit. Nothing in that rule requires that the state, in response to a motion to suppress, has to file a written response. Then moving to your other order, the other motion that you filed under, or the rather rule that you filed under, Rule 49 provides the following. Serving and filing of papers. A, when required, a party shall serve on every other party 1, written motions other than those heard ex parte. 2, written notices. 3, each order required to be served by the term of the order. 4, designation of record on appeal. And 5, similar papers. Service, how made. 1, upon an attorney. I'm not going to read all of this. 2, method of service. Service of copies of document on an attorney shall be made either by delivery in person, mailed to the last known address, leaving a copy with the court clerk, or you can do it by electronic service. Definition of delivery is placing in the hands of the attorney or the party, leaving it at the person's office with a clerk. C, if the office is closed, a person to be served has no office, leaving it at the person's dwelling house. Subsection C, filing of served papers with the court. Papers are required to be served shall be filed with the court as follows. Signature with the court clerk. Duties of the court clerk, they shall endorse on every pleading and all other papers filed in a proceeding how the date and hour of the filing. And it goes on to say recycle paper. It also provides service by pro se inmate, which would determine you filing thing. That is the extent of that order. There is nothing in that order, in that rule, that requires the state to file a written response to your motion to suppress. Therefore, your motion, your judicial notice / notice of objection to the state's failure to file a written response to the motion to suppress is respectfully overruled, and we are ready to proceed. State may call your next witness.
Excuse me, Your Honor, can I make an objection to that? It doesn't state the request that the DA file a written response, but it does require that the state give notice and of anything that she files into. I have not received a notice of who her witnesses was, or I haven't even been.
There's no requirement, Mr. Vaughn, of that. There's
So-
nothing in the rule that you filed under that requires the state to give you notice of the witnesses they're going to call, nor does it require them to give you notice of any writing that they have. And to my knowledge, the state has not filed any written response. Is that correct, General Bryson?
That's correct, Your Honor. What about notices for court dates? I've twice in this court, I've been called to court without even giving a notice.
There is no validity upon your objection to, based on those things, and your motion has been denied, so we're moving forward. All right, General, call your first witness.
State calls Corporal Lindsay Javens.
Corporal, if you'll come forward, please.
Still ain't got all my questions. I can start.
Corporal, if you'll slide the base of that, there you go, thank you. Officer Moyer.
I just ain't got much.
Are you Corporal Lindsay Javens?
Yes, ma'am.
Would you spell your first and last name for our court reporter?
First name Lindsey. Last name Javens, Jav as in Victor, INS.
And Corporal Javens, were you, how are you employed?
I'm a corporal with the City of Dixon Police Department.
How long have you
Patrol.
been in law enforcement?
I have been in law enforcement since 2017.
Was all of that with the City of Dixon, or have you worked anywhere else?
Prior to that, I worked for Fairview Police Department.
On June 18th of 2022, were you working with the Dixon Police Department?
Yes, ma'am.
And that night, did you come into contact with the defendant, Sharik Vaughn?
Yes, ma'am.
And what was the reason for coming into contact with him?
Originally, we had a call for a possible domestic at Walmart. The vehicle description was given that he was making threats to kill the female and the children.
And did you make contact with him at Walmart or somewhere else?
I observed them pulling, they had just pulled onto Beasley Drive. I observed the vehicle, same tag, all of that, and I made a traffic stop at Dollar General on Beasley Drive.
So you initiated your blue lights, it's a full-on traffic stop.
Yes, ma'am.
When you approached the vehicle, who was driving?
Mr. Vaughn.
And how did your conversation with Mr. Vaughn go?
Well, I asked Mr. Vaughn to step out of the vehicle due to it being a possible domestic. I wanted to separate the parties to look into what was going on. He refused to do so. I asked him approximately 8 times to step out of the vehicle, and he refused to do so, even after being told of his obligation to do so. I had to open the door and assist him out of the vehicle.
Ultimately, did you place him under arrest?
Yes, ma'am. So also during that time, during the investigation on scene, it was determined that his license was revoked as well.
So you initially arrested him for resisting,
Resisting and driving unrevoked.
and the state's not moving forward on the resisting charge, but he's still being prosecuted for driving unrevoked.
Yes, ma'am.
Did you confirm that he was revoked? Did you learn that by speaking to him, or was it something that you ran a system?
It was through dispatch.
Once you got to the jail, let me back up. He has been charged with retaliation for past action. When was the first concerning statement that the defendant made?
As we were entering the jail.
And what did he say as you were entering the jail?
As we were entering the jail, he told me that he was a threat for a reason.
And did you clarify that?
I did. I tried to clarify. I asked him again. He said, I'm a threat for a reason.
And were there any further statements that were concerning to you?
Yes, ma'am. So I had obtained my warrants by meeting with the magistrate before I went to the jail. Got to the jail to serve those warrants, and so he could be booked. I was up doing my paperwork. I had finished completely, and the jail staff still had him in handcuffs. I told them that I needed my handcuffs so I could go. There was some hesitation with the jail staff to remove the handcuffs, and they went around to try to remove them. At the beginning, I was assisting, and then he became upset because I was assisting because I was touching him. So as soon as more people got over there, I stepped back so that I was no longer touching him. During that time, they were trying to get the handcuffs off, and not a direct quote. We may have to do the video for the direct quote, but he was saying that whenever I got hit in the jaw, that it was going to be their fault because they wouldn't let him go because they were trying to take the cuffs off. Then the female jailer was telling him, like, please stop tensing up so we can get the handcuffs off. And he said, believe the direct quote was, "Fuck no, I'm going to beat that bitch up."
Taken all together, did you take those statements to be in reference to you?
Yes, ma'am.
And then before the charge was taken out, of course, you heard the testimony of Stewart last week.
Yes, ma'am.
Did those add to your perception that these remarks were directed at you and law enforcement?
Yes, ma'am. So after the incident, we spoke, and he encouraged me to document, because I explained to him what he was said to me as well. He encouraged me to document that in my report just in case something did occur in the future. And he did happen to, try to assault me, harm me, kill me, as he implied. So that was documented in my report. And then whenever it went to grand jury, that's whenever that charge was added.
Nothing further at this time, Judge.
Mr. Vaughn, you have the right to question this witness. If you wish to question the witness, you'll need to come to the podium, please. And I would remind you that this is not an opportunity for you to make statements. It is an opportunity for you to make a question.
Yes, Your Honor. Your Honor, will my elbow counsel be allowed to make some follow-up questions after I'm done?
He is your elbow counsel. He cannot ask questions, but he can assist you in asking the question. You've elected to represent yourself, so his role is to give you advice in counsel, not to actually actively participate in the trial, unless you want him to. If you want him to, then I'll allow it. You want him to assist you?
Yes, to assist me, yes, as elbow counsel, yes. You allowing that?
You may.
All right, thank you.
That is not the role of elbow counsel. Elbow counsel is not to ask questions. It is not to participate in the trial. It is to be there as backup.
Can you say your name for me, please?
Lindsay Javins.
You go Javins, Ms. Javins?
Javins, yes, sir.
Okay. I believe what will you tell the courts what you did? What did you arrest me for again? What was the reason for your arrest?
Driving on revoked and resisting.
Driving on revoked and resisting. Okay. Driving on revoked was the charge that you gave me. No, excuse me. Let me rephrase that question. Resisting arrest was the original reason you arrested me, correct?
I arrested you for driving on revoked and resisting.
So when you pulled me out the car, you were planning to arrest me for driving on revoked and resisting, correct?
You were removed from the vehicle, and yes, you were going to go for resisting, yes, sir, but you were also revoked. Whenever I went to the magistrate to present my affidavit to them, that was for driving on revoked and for resisting arrest.
Okay. Okay, so the original charge was resisting, correct?
The two charges together, that was what was presented to the magistrate.
Do you believe that your arrest was justified?
Yes, sir.
You believe that you did that to your best of your abilities?
Yes, sir.
You don't believe there was no illegal intent or malicious intent involved in it?
No, sir.
Do you believe that I truly resisted arrest?
The fact that I asked you 8 times to get out of the vehicle and you failed to do so to the point where I had to open the door to get you out, yes.
So did I use any force, resistance, threat of flight, or harm to you?
You remained in the vehicle and did not get out.
So that's a no?
I did not have to fight you, no. After the door was opened and you got out with me.
Okay. What was the reason for you wanting me to exit the vehicle?
I was investigating a domestic because I had a call for service stating that you had made threats to kill the female and the children. So I made contact with you. For a domestic, we want to separate the parties to be able to hear both sides. You were asked to step out of the vehicle and didn't do so.
Is that the only chosen method that you could have used, or is that just the one you chose? To have me, to separate us?
That was the method that I was going to choose, yes,
That
to
you
separate
chose.
you. That is what we do in domestics.
Okay, is there any other methods that you can use, or is that the only one?
If you'll clarify what you're asking.
Could you not have asked the alleged victim to step out of the vehicle?
I was asking the driver to step out. I can pick whichever one, and you were refusing to do so. You were the one that was making the threats. I think that it's more pertinent to separate you from the situation than anything.
You keep saying that I was the one to make the threats. Is there any proof that I made these threats?
I had a call for service that you were making threats. I was investigating those threats that were made. That's what I was there for.
So you believe those threats was made by me?
I didn't arrest you for domestic, but because I didn't have any cooperation, but there was a reason that I was called out there.
So you didn't have any proof, correct?
A domestic arrest was not made due to the uncooperation of the victims.
Okay. You believe that there was a victim actually in this, for the call?
I wasn't called for no reason.
Do you, but like when you, from your own personal knowledge of the scene when you arrived, do you actually believe that there was a victim? Like, do you believe that someone was beat up or threatened or in fear for their life?
That's what I was investigating.
So when I'm asking you, do you believe that she was a victim?
Turn your microphone on, please.
Judge, I'm going to object to relevance at this time. There was no charge for domestic, and so this really doesn't pertain to the motion.
Mr. Vaughn, the objection is as to relevance. The officer has testified that she was investigating a domestic violence case, or at least a domestic violence call, which means that she was there to investigate. Whether she believed there was one or not, is irrelevant. The question of whether there was or was not one is technically irrelevant, because if she is responding to a call of a possible domestic violence, that is her reasons that she's testified to for stopping the vehicle and engaging with you. And at that point, her personal belief as to whether or not there was or was not a domestic violence is not relevant. So I sustain the objection. You may ask your next question.
I'm going to object to that, Your Honor. The relevant said the case. I mean, it was for a domestic. To see how she approaches the situation domestic involves the entire case. It all stemmed from the original call. So there is some relevancy to the fact what was she visually seeing. I mean, she's later on making statements like, what is your view of everything? I want to see, how do you see things? Like, she should be able to answer that question, Your Honor.
I've sustained the objection, Mr. Vaughn, and so I consider your argument. But an officer who is responding to a call almost never knows for sure what is taking place. They're there to investigate. That's the whole purpose of the investigative stage of a criminal case. An officer who responds to a call is given a limited amount of information. They are responding to it in order to make that investigation to determine whether there was or was not a crime committed. And that gives them the opportunity, the probable cause, to engage with a citizen and to talk with the citizen about that investigative stage. And then if they determine there is a crime being committed, then they can do that. But that also allows them to investigate and engage a person. And if they determine that that person has committed a different crime than domestic assault, then the law allows them to engage and charge that person for that. So I have sustained your objection of the state, and I'm instructing you to ask your next question. I've noted your objection, your disagreement with my ruling, but I am telling you, you need to move forward. You preserved your objection, so let's move forward.
Do you believe that you was emotionally attached at any time during this arrest?
What was your question?
Does she believe that she was emotionally attached any time during the arrest?
Emotionally attached? Can you
Yes.
clarify?
You responding to a domestic violence as a female to a domestic violence on a female. Do you believe that you were emotionally attached in any way, form, and fashion?
I was doing my job.
Okay, so that's a no?
I was doing my job. I don't hold any personal feelings towards my job. I have a job to do and a law to abide by, and that's it.
Okay. Do you recall making a statement that I believe that she is a victim?
I do not recall.
Did you at any time see that you could have de-escalated the situation between you and I at the scene?
If you would have stepped out of the vehicle the first time I asked, there wouldn't have been escalated.
So there was no other option to de-escalate after that? Once a situation occurs, there is no de-escalation after that?
What are you asking?
After I stepped out of the vehicle, there was words back and forth. Did you feel like we needed to de-escalate further?
I don't feel like there's ever was a further problem.
Okay. Okay, when we got to the jail, we walked in the jail, why didn't you take the handcuffs off when we walked in the jail?
We don't take the handcuffs off, the jail staff do.
Okay. When you see that I was agitated, did you feel like that was a de-escalation situation?
You were in the custody of the jail at that point.
Oh, I was
I
in the-
just needed my handcuffs to
So-
leave.
So you were assisting them when you placed your hands on me?
I briefly held your arms, your one arm, to assist them because there was just one or two people right there. So until they got more people, whenever they had more people over there, I stepped back and took my hands off of you.
You said they only had how many people again?
Originally, there was only like one or two people right there. That's why I was assisting. And as soon as more people came, that's whenever I stepped back.
Was I resisting them, or was I putting up a fuss or fight with them at this time when you intervened?
Yes, sir.
You stated that the reason you didn't take the handcuffs off when you came in the jail because I was in their custody. That means that your responsibility ended at the time, correct?
I'm not just going to stand there and watch somebody fight and resist from someone and put them in any type of danger. No, I'm not.
What do you call fighting and resisting? What does that look like to you in your own words, please?
Can you clarify?
What does fighting and resisting look like to you? Like if you see somebody fighting and resisting, what does that look like to you in your own words? Can you paint the picture, please?
Resisting would be preventing them from removing the handcuffs is what was happening.
So pulling away, maybe arguing? Okay.
Making those threats, pulling away, tensing up to where they couldn't remove the handcuffs.
Okay. You stated that earlier along the lines of, I made the statements of, I'm going to beat you up, B, correct?
Yes, whenever she was asking you to stop tensing up, that is what you said.
Was I speaking to you?
You said that out loud. You did not say that directly to me,
Oh, so
but
I
I was
didn't
right
direct
there.
it to you, but you believed it to be towards you?
Absolutely.
Okay, do you also recall, you made a statement, it's on my other notebook.
This one?
You said, you made a statement to me as we entered the jail, when you said that I allegedly said that, I am a threat. You made the statement. You said like you were threatening me, but it's cool. What do you mean by that statement?
Whenever I was walking up to the jail counter, I made the statement that I think, if I recall correctly, you said something about not threatening, and I said it seemed like a threat to me, but it's cool. If I recall correctly, that's how it was said.
Yes, what did you mean by it's cool?
That it's fine. I mean, you're going to threaten me. Later on, you made very thorough threats.
Let's stick to the question I'm asking you. So what, you said it was cool. Like, does that mean you feel harmful? Does that mean that, well, oh, that ain't nothing, you're just talking, or what does that mean to you?
It's cool. You made the comment. It's cool. If that's
So
what you want, do you want me to answer?
You can go ahead.
Okay. What I was saying is that it's cool. If you want to threaten me, then you can threaten me.
You just blew it off your shoulder, basically. Would you please use your words?
You stated you were a threat. I said it felt like a threat, but it's cool.
So you blew it off, yes, correct.
I'm not saying I blew it off. I'm just saying that it's cool. If you want to threaten me, you can threaten me.
Did you feel threatened at any time?
During that whole encounter, up until me leaving the jail, yes.
So do you normally laugh when you feel threatened?
Sometimes, a
You
little
do?
uncomfortable.
When you feel uncomfortable?
Yeah.
Okay. So do you recall the statement, he's just acting tough, he's just acting bad? Is that normally like a fearful statement?
I believe that your demeanor changed from the time that we were coming in, like when we went into the jail, your demeanor changed. And then when you believe that when they were trying to take the handcuffs off, you were acting completely different, yes.
Do you believe that I would actually retaliate against you?
I do.
You do?
Yes, sir.
So if you believe that, then why did you take so long for the charges to get filed for retaliation? It's 5 months after your arrest.
To be completely honest with you, I didn't know that that was a thing. If you want me to be completely and totally honest with you, when they made me aware of that, I was like, oh, I didn't know that that was something that could be added on.
So it took you 5 months to figure out that you felt in harm and fear?
No, I did not know that retaliation
Mr.
after
Vaughn,
the fact was a charge that could be used.
To explain that, she didn't bring the charge. The grand jury returned this indictment. So it's not that she went to a magistrate and obtained a charge 5 months afterwards. The new charge was added by the grand jury when it was considering the driving on a revoked license and the resisting arrest. They added the third charge after hearing testimony.
Well, what I want to ask her next was, why didn't she file it then? You had 5 months.
And ask
She made
that
it in her
question.
statement. Her statement was on time?
Then ask that question.
Okay. So once you found out about the resisting arrest, that it was a possible charge that you can charge, why didn't you file it?
I was well aware that resisting arrest is a charge.
You was well aware that it was?
Resisting arrest? Yes, sir.
No, I'm sorry, excuse me, retaliation.
I was made aware during the grand jury proceedings.
Okay, so that's why you didn't file it, but you just took note of it in your report. That was the only reason, just for future reference.
For the notation of the threats that were made in my original report, yes, sir, I notated in there just in case some further incident happened. Absolutely.
Okay, was there ever any actual retaliation tried by me or anyone?
I've never seen you other than that incident and in court.
No calls, no threats, no nothing, no contact whatsoever?
No, sir.
Okay. But you believe that a retaliation was still possible?
Absolutely.
Okay. How long after the encounter with me did you decide, before you found out that I was allegedly driving on revoked?
What are you asking?
After the first contact you made with me, how long did it take you to find out or find an alleged driving on revoked charge? Was it
While we
before
were-
you placed me in handcuffs or while we were at the jail?
While we were still on scene, I met with the magistrate before we ever went to the jail.
You met with the magistrate before we went to jail?
Yes, sir, at the police department.
Yes, that's when you found out it's at the jail?
No, I found out on scene that you were revoked from dispatch. So at the time that you were transported, I was well aware that you were revoked.
Okay, would you say it was about 15 minutes, 20 minutes maybe?
I don't know the length of time, but I know prior to you being transported, I knew that you were revoked.
Okay.
May I briefly?
You may.
You're fine. It's Lindsay Javens.
Your rank, I'm sorry.
Oh, corporal, I'm
Corporal,
sorry.
Okay, I always do that. So when you say on scene, you still consider the the police department to be on scene until you actually get to the jail, is that?
No, sir. I'm saying on scene as in Dollar General. I knew he was revoked before we left Dollar General, before he was transported to the jail to meet the magistrate.
Okay, all right. And that is driving on revoked or suspended, that is a catch and release statute, correct? You could have issued a citation, correct?
Oh, okay, I see what you're saying. We can issue a citation unless it's significant numbers. There's clarification of time that we can and can't issue citations.
Significant numbers.
Like if someone has 4 priors or 5 prior driving on revoked, that's indicating that the likelihood of the offense is going to continue if they continuously are getting driving on revoked charges.
Okay.
So that is an exception to the citations.
Did you note that in the warrant?
I'm not saying that that was applicable in this situation. I was saying that that's a time that they wouldn't be arrested.
But if
Or, I
somebody.
mean, they would be arrested, not a citation, sorry.
Right, and Miss Dozier, she was, Dozier, I'm not sure, she was present, right?
Yes, sir.
Did you run her driver's license?
I believe so, yes, sir.
Was it valid?
I do not recall.
She drive off from the scene?
I do not recall.
She wasn't placed in custody, though.
She was not taken in custody, no, sir.
So, in theory, she could have driven away from the scene in lieu of Mr. Vaughn.
If
Right.
she had a valid driver's license, yes, sir.
And you issued the warrant primarily on this resisting theory.
Resisting and driving unrevoked.
Okay. But you determined the resisting first, right? You determined that you were going to charge with the resisting first in time that night. Then the driving on revoke.
They were presented to the magistrate at the same time. He was,
But you, in your mind, you witnessed what you would say. Did you run his driver's license before you placed him under arrest for resisting?
I believe that he was placed in handcuffs after I got him out of the vehicle and put him at the car. The point where he was transported to go meet the magistrate, I was well aware of the driving unrevoked and the resisting.
Okay. You didn't run her driver's license?
While on scene, I typically would log all parties, so I believe that it was logged. I just don't recall if she was valid or not.
Okay. But your report says you couldn't determine who the aggressor was in the alleged domestic, right?
I could not determine that there was a primary aggressor and that an assault occurred for the domestic.
Okay. So absent this resisting charge, it's likely that you would have issued him a citation and let him go, right? Had he not done what you perceived to be resisting arrest. And let her
Possibly so.
drive.
Well, that's absolutely a possibility, but he got stupid.
Possibly so,
That's possible.
possibly.
And had he not been out there cuffed up in handcuffs, these statements are never made, this evidence is never obtained, is it? For this charge that you didn't know existed. Correct?
Can you clarify what you're asking?
If he's never arrested for resisting arrest, and he's issued a citation in lieu of arrest, and Ms. Dozier is allowed to drive away from that scene, and Mr. Vaughn is never in cuffs and taken to the sheriff's office out here where the jail is, correct?
Yes, sir. Correct as in that's where the jail is.
Well, in that scenario, he never would have been taken there that night by you either. That's correct, isn't it?
He was taken in custody for driving unrevoked and for resisting. That was presented to a magistrate and probable cause was found, warrants were signed.
Understand that, but that's what I'm asking you. You would have been able to issue him a citation if not for the resisting charge, right?
You're asking a hypothetical situation.
This lawyer is just as bad as the person he's representing. This is terrible.
Telling you what occurred, that's what occurred.
Asking you, okay, then let me ask you specifically, had he not resisted, would you have issued a citation?
I could have possibly issued a citation.
Would you or would you not have?
Depends on the situation, the circumstances, how many priors he had.
The circumstances as they were that day, how would you have done it?
The circumstances, how they were that day, I
Absent-
would have done the same thing that I did.
Absent the resisting portion that you claim was resisting, and you came up there and nobody wanted to talk about you about what you perceived as a domestic, would you have just simply issued a citation to him? Take out the resisting part.
Yes, sir. Like I said a second ago, that is a possibility that could have happened.
Okay. And had you done that, he would never have been cuffed up, would he? In the event that you had issued a citation, right?
Are you saying that he never would have went to jail? Is that what you're saying?
Yes.
Yes. If I issued a citation, I do not take someone to jail. That is
Okay.
correct.
Okay. And at that point, you're not having to get your handcuffs back, are you?
No, sir.
And he's not making those statements, is he?
If we're not at the jail, that's a hypothetical situation. If he was not issued a citation, if he was issued a citation, we would have never been at the jail.
Okay.
That help?
And you have, count two, that resisting has been dismissed, right?
They elected to dismiss it, yes, sir.
Okay. And you put your hands on him, and all he said is, "I'm not getting out of the car," right?
I
You
opened
opened the
the door and then we got out of the
put your
vehicle.
hands on him. At which point, Mr. Vaughn then showed you before you do that, before you do that, he had a weapon on him, correct? And he showed it to you. Was there a knife?
Yes, sir.
right? So he was making sure that you were aware of the circumstances, right?
Yes, sir.
And so you didn't misinterpret his intentions that night, correct?
Misinterpret what intentions?
Well, he wasn't charged with an assault against you, and a knife can be considered a deadly weapon, right?
Yes, sir.
So if a suspect concealed a knife, then that would be a charge. He didn't conceal that from you at all, did he?
He
fact,
made
he
me
didn't-
aware that he had the knife.
Okay. And had he not, and you found that on him, that could be a basis for some sort of assaultive offense, right?
For having a pocket knife?
If you were afraid of it.
No, sir, I would not say that would be an offense or an assault to have a pocket knife.
But he was being cooperative and telling you in advance that he
After
had
the,
that knife.
after the fact, yes, sir.
Okay. And you did go out there and said, it's cool after he talked to you the first time, right?
After he told me that he was a threat.
Well, after what you say, he said, sure, if that's what you say, he said, you said, it's cool.
Yes, sir, that was before the next two statements.
Okay. But at that point, you didn't feel threatened by saying if you said it's cool.
He said I'm a threat.
And you said it's cool, which would not be indicative that you felt threatened, would it?
No, sir.
Okay. And you, I believe, said that you became threatened after Corporal Stewart made you, or you felt more threatened after Corporal Stewart told you what he said after you were gone, right?
No, sir. That's when we spoke about what he told to Corporal Stewart as well. That's whenever we talked about making sure that it was documented in the report.
Okay, so Corporal Stewart's statements about what he said, those didn't play any factor into you adding this charge at grand jury?
It contributed to the whole circumstance, yes.
Okay. And you heard Corporal Stewart testify the other day, right?
Yes, sir.
Okay, and you were not, your name was not mentioned specifically whatsoever in what Corporal Stewart heard. All that?
There were no names mentioned to my knowledge.
And so there was no direct threat made, indirect or direct threat made at you specifically, based simply based on what Corporal Stewart heard and testified to.
If I recall correctly, he testified that he took the threat to be to law enforcement.
But law enforcement's not named as the victim in this indictment. You are.
I am law
specifically.
enforcement,
Okay,
technically.
but you're the only one that's named in this indictment.
Okay.
And your name was not mentioned specifically whatsoever.
He did not specifically say my name, no, sir.
Okay. And you're only, and you said you ran his driver's license on the scene at Dollar General
Yes, sir.
before you went to the police department?
Yes,
To
sir.
the magistrate. And I know I've gone over this, but you had already had in your mind that you were going to charge him with an arrestable offense, right? That's why resisting arrest, you're going to get warrants. You saw what you perceived, at least, as resisting arrest on that scene, right?
Yes, sir. I believe that he was resisting and that he was driving unrevoked. He was taken in custody and that was presented to the magistrate.
And the resisting would nullify nullify the practicality of issuing a citation for the driving on revoked. Because you're cuffing him up anyway for resisting.
As I said, that's a hypothetical situation. That he could have been issued a citation, yes, but there are other things I would need to look at. If it fit any of the exceptions, then no, he wouldn't have been issued a citation.
Well, he wasn't going to be because you were going to arrest him for the resisting. So it wouldn't have been a need for a citation anyway, would there?
Brad,
do
I
you-
think you've asked that question about 5 times.
Yeah.
And I've not, believe Your Honor, gotten a direct answer.
She's answered it in the form of that under the facts of the circumstances, this is what she did. If she could have issued a citation, she said that. If she'd issued a citation, he would not have gone to jail. If he hadn't gone to jail, he might not have been charged with retaliation. All of that, you've made that point several times. Is there some other question that you want to ask?
No, Your Honor, not specifically on the point. I just wanted her to answer me as to the citation was less likely to be issued because she had what she perceived as an arrestable offense. I don't think I've gotten a straight answer to that.
Well, with the citation,
No,
I'm
you
sorry.
Go ahead. You got it.
With the citation being issued, if I'm going to issue someone a citation, I have to make sure that it doesn't meet those exceptions. If it meets those exceptions that are outlined in the law, then I can't issue a citation, and I should take them in custody.
Did you go through those exceptions that night?
No, I did not, because there was resisting and a
Okay.
driving on revoked.
I think that's what I was asking. So.
But you're at like a hypothetical situation of, for sure that I would issue a citation, I can't say that. I absolutely would have issued a citation. If it met those situations, the exceptions in the law, then he would not have been issued a citation.
But you never got to those exceptions because you had, I mean, I think that's what you just said. You never checked those exceptions because you were arresting him for resisting.
He was arrested for both, yes, sir.
Okay. Those are my questions.
Is laughing sometimes a form of de-escalation?
Yes, ma'am.
Now, you talked about those exceptions under the law. One of the exceptions to citation in lieu of arrest is if someone, if there is a reasonable likelihood that the arrested person will fail to appear in court.
Yes, ma'am, that is.
And you didn't look into how many FTAs Mr. Vaughn had because you were already arresting on something else. Is that right?
That is correct.
If someone has multiple failures to appear on their criminal history, would you issue a citation in lieu of arrest or would you arrest?
I would arrest if there was a likelihood that person would not appear in court.
Nothing further, Judge.
Anything further for this witness?
Corporal Dravens, you have been asked by both the defendant and elbow counsel multiple times on the timeline of when you realized that the defendant was revoked. Have you watched your entire video start to finish to be completely sure of the exact moment?
No, ma'am.
Do you even know if it's going to be on your video when you find out that he is revoked?
It could be, but during the investigation, I ran, his license and I was informed, and I know that was before I would have went to meet with the magistrate.
Yeah, before you went to the magistrate, you found out that he was revoked,
Yes, ma'am.
but you don't know exactly what moment.
Not the exact moment.
So just throwing out the possibility, it is possible that it wasn't until you got to the police department with him.
Could be, but I would say that I knew on scene.
Nothing further, Judge.
All right. Anything else?
The same question she just asked you about the time limit on the arrest. Would you say 30 minutes is roughly too long to find out if someone's driving on revoked?
I don't have a timeline on the amount of time that I knew that you were revoked.
Is there any policy or proper procedure that you go by to stay in lawful to a pullover?
Yes, it's just like ordering a pizza. If the arrest is not concluded within 30 minutes, you get it for free.
Well, I cannot detain someone for longer than reasonably necessary. if that's what you're asking.
Okay, would you say that reasonably necessary after I was placed in the back of the car and we were leaving the scene, do you think that was, would that be considered a reasonable time?
Can you clarify what you're asking?
Once you decided to place me in the back of the car and we were leaving the scene, would you consider the investigation done, that was the reasonable time to end the investigation? Or should we take it to the police station and continue an investigation?
You were taken in custody and it was presented to the magistrate. I'm not sure what you're asking.
You're familiar with what you think a reasonable time would be, correct?
It depends on the circumstances.
Okay, so do you believe that when we left the scene, that the investigation should have been concluded?
You were taken in custody.
Yeah, so does that mean that the investigation prolongs after that custody? I mean, if you choose to investigate anything, are you required to, do you feel permitted to go on further past that? If you take me into custody and you want to keep investigating, is that okay?
Can you clarify what you're asking?
All right, when we left the scene and got to the police station, is it okay to continue to investigate?
Absolutely.
Okay, so what I'm asking you is, when we left the original scene before we got to the police station, you were not finished with your investigation?
You were taken in custody and you were transported there. If I didn't know that you were, I believe that I knew on scene, but if you're implying that I didn't know until we got to the police department, they were presented to the magistrate at the same time. I don't know that that's relevant.
It is when it comes to, well, I can't make statements. That'd be all, Your Honor.
Anything?
One more, I believe, my
No,
assistant.
I allowed him to assist by asking a couple of questions, but that's not the role of elbow counsel. The Tennessee Supreme Court in State versus Small, which is at 988 Southwest 2nd, 671, defined the role of elbow counsel. When you have elected to represent yourself, then you have waived your constitutional right to counsel. It is within the court's discretion to appoint elbow or assistant advisory counsel, which I have done. And the role of a advisory counsel, also known as elbow counsel, is an attorney who functions in a purely advisory role to a pro se defendant without actively participating in a trial. Pro se defendant who is permitted to such counsel may consult with the counsel for guidance and advice, but otherwise handles the defense of his case on his or her own. So Mr. Spratt can sit there and give you advice, and that is his role. He's not going to be allowed to question witnesses and otherwise make statements or have any other role other than giving you advice, because you have waived your right to counsel. So
Okay, can I seek advice from him then?
you may.
Your Honor, I'm gonna ask you permission to read since Ms. Danny Bryson brought up the video, that I'll be allowed to play the video in open court.
Do you have any other questions for this witness? You want to play the video in your response to the state's evidence? Is that what you're saying?
Yes, sir.
State have any objection to that? Then we'll allow that to take place. I just want to allow the officer to step down if you have no other questions.
Is it possible that I could play the video to ask her further questions about what she views in the video?
Let's let the officer step down. Do you have any other witnesses?
Judge, I think the video may be being played at attempt at impeachment, and so if so, she would be able to respond after it's
All right.
played.
Well, let's bring the video up and let's get it hooked up, and we'll allow it to play it if it's part of his cross-examination. Who has it? Who is playing it, I guess is my question. Mr. Spratt, I'm going to step off, take a short recess while we try to get this queued up. Let me know when you're ready.
All rise. This court is in recess.
It's been requested that we play this video. Let's dim the lights, please.
Ready when you are, Your Honor.
Ready.
welcome to jail again or not. Hello. How you doing? Good. How about I come back here and talk to me real quick, man?
I'm not stepping out of the vehicle until you tell me the reason.
Well, we got a call that there's a domestic, so I just want to talk to you about
Call
what's
for a
going.
domestic,
Yeah.
what makes a domestic?
I got you. Somebody just called. Let me come back here and talk to me real quick. We'll talk about
I
it.
can't step out of the vehicle until I
You
committed a
can't.
crime. I reserve all my rights.
All right, well, let me tell you this. So Pennsylvania versus Mims, case law says anytime I tell you to step out of the car, you step out
But I
of the
know,
car.
but you also know.
Case
like,
law says,
hold on,
no.
I'm gonna let
Case
you
law
speak.
says if I tell you to get out of the car, you get out of the car.
Can I have a
So
male, can
get
I
out of the
supervisor
car.
come to the room?
Well, they're coming. You're gonna get out of the car when I ask you
don't feel comfortable
to.
right now because as a female president, it's a male domestic. I've been in this
I'm
many
not.
times.
I'm just trying to talk to you.
Okay.
You're making this a thing.
No, I'm not.
Step it up for me. I don't want to talk to you. I want to talk to you separately, okay? That's how I want to do it. That's how we do domestics. We're going to talk to you separately. That's how we're going to go. So I'm going to get you to step out of the car. Look, this is
Am I
going
under
on.
arrest?
You're going to step out because I'm telling you to step out
Where am I
now.
gonna stand and am I under arrest
Step
before I
out
step
for
out of
me.
my private vehicle?
You're not under arrest right now. I just need to
Then I
talk to
have no
you.
reason to step out. I'm still not under arrest.
Step out. You're going to go to jail for resisting.
I asked
The
you-
second I put my hands on you and you don't get out of this
I asked
car,
you
you're
a
going to
question.
go
You
for
do not answer
resisting.
correctly. You know this.
There ain't nothing about it. I just
If
told
I'm
you.
not under
I
arrest,
just
you
told
have no
you.
reason to touch me.
Case law says if I tell you to get out of
It's
the car,
not
you
about
get out of the car.
touching. If you say I'm
It
under
is.
arrest,
Get out of the car. Come on. Get out of the car. Get out of the car. I told you to get out. Get out of the car.
Don't get out. Don't.
Get out.
Well, hold on. Grab that before
You're
you
good.
touch me.
That's
You're
our
good.
work knife.
I ain't worried about that. Come back here and talk to me. Stop making this a thing.
Is that a male in that car?
Yes, there's two males in that car.
I want a
Go
male
up
to
here.
touch me. Please stop touching me.
Go up here. Go up
I
here.
want a male to touch me.
Yeah, there's gonna be a male that's gonna touch you. Put your hands on
Male,
your back.
please touch me. A
There's
male,
gonna
please
be a
touch
male
me.
that's gonna touch
A
you.
male, please touch me.
All right.
There are no females to touch me.
Dude, chill out.
See, you're being disrespectful.
You've
I'm not
been
being
disrespectful since
No,
I walked
asked you,
up here.
am I under arrest? You said no. It ain't no shut up. Am I under arrest? And you said no. Then why am I
Did I
detained?
tell you to get out of the car? Did I tell you to get out of the car?
Am
Did
I
you
under
get
arrest?
out?
Am I under arrest?
Did I tell you? Now you are.
I reserve
Now you
all my
are.
rights.
Now you're going for resisting at minimum because I told you to get out of the car. You didn't get out of the freaking car. How many times did I tell you to get out of the car?
No, you're not.
No, he's not. No, you're not.
Right now, I think.
All right, ma'am.
We was arguing with you.
You step out and talk me away from the kids, please.
Yeah, we were just arguing.
I got
We've been
you.
together 15 years.
I got you. Well, there's enough that's already.
Miguel.
Listen. There's a.
Your Honor, I would like to stop that right here and request now the time to ask some follow-up questions.
All right, officer will return to the stand.
Your Honor, I would also like to request that the courts move that into exhibit as a hearing.
We will mark it as an exhibit to this hearing after the conclusion of the playing whatever portion you intend to play. And the state may elect to play more of that, we'll see. But you may go ahead.
How did that help him? How, in what world does this man think that that video helped him?
Okay, up to this point of the video that you've seen, would you classify that as the resistance that I was arrested for?
Yes, sir.
You would. At this time, did you go through the cite and release or the arrest? Yeah, the cite and release. Did you have time to go through it then?
At that point in time, resisting. I asked you to step out. I told you when I had to put hands on you to get you out. And whenever I reached to help get you out, you jerked away from me and then went to get out.
I jerked away from you in that video?
You pull away. As soon as I touch you, you pull away. I mean, if
You sure I wasn't reaching for a
court-
seatbelt that was across my chest? To unbuckle the seatbelt and get out of the vehicle?
you'd like, I mean, it's up to you if you want to play it again.
It's up to you. I'm the judge. If he would like to see it again, I'm familiar with it. It's up to you if you would like to see that again, Your Honor.
Do you want to see it again? I don't think it's necessary that we replay it again, she's answered your question, and this is not an argument between the two of you. This is question and answer form.
Yes.
So ask your next question.
1 second, Your Honor, may I speak to my counsel?
Okay?
The segment of the video that we just viewed, so would you agree that I was arrested for refusing to get out the vehicle at this point?
For resisting, yes.
Yes, that's the only thing I was, at this point in the vehicle. So there was no other offense up to this point?
At the point where we're paused right now, there was resisting. I said you're going to be arrested for resisting at minimum.
Okay. I believe that's all, Your Honor.
All right, are we playing any more of this video? All right. Thank you, officer. Do you have any further questions for the officer? Thank you, Corporal. You may step down.
Yes, sir.
All right, you may call your next witness. General State is putting on their proof.
Um,
On this 336 indictment, the state has rested their proof on your motion to dismiss or suppress. You now have the option of putting on proof of your own. Do you wish to offer any proof?
Yes, I would like to make a note of the video first, Your Honor, if I could.
You want to,
I want to clarify that that was just the first 3 minutes of the video.
that's fine. We're going to make the video
Six-
an exhibit
6
to
seconds.
this hearing.
Excuse me, Your Honor, I didn't hear that, please.
We're going to make the video an exhibit to the hearing, and you're going to have to designate the first 3 minutes, is that what you said, is the portion you're relying upon?
3 minutes and 6 seconds, yes, sir.
3 minutes and 6 seconds are the portion that we're relying on, that you're relying on. All
Yes,
right.
sir.
Then it'll be noted on the record.
Yes, sir. I would like to call my witness now at this point.
Who?
Jennifer Dozier.
All right.
Excuse me, Your Honor. While we're waiting, is it possible that I can recall Javens and ask one more question, please? And my proof?
State has rested and you had failed, but I'll allow her to come back to the stand for you to ask one more question. Officer Corporal, I would remind you to remain under oath.
Yes, sir.
At any time, did you Mirandarize me?
I'm sorry, repeat that?
At any time, was I Mirandarized?
Were you what?
Mirandarized. Did you read me my Miranda rights?
Not that I recall.
Not that you recall. Is that normal procedure too? When you're going to arrest someone to read their Mirandarization?
Not every time, no, sir.
Not every time. With this situation, would you say cause for it? This arrest, pertaining to this arrest?
Pertaining to this arrest,
Would
no,
you-
I didn't need to, I don't think that I was asking you any questions related to resisting or driving on revoked. If I was asking you questions, if you were being interrogated, you would need to be advised of your Miranda rights, but you were not being interrogated.
Okay, thank you. That's all. Your Honor.
Thank you, Corporal. Hopefully this time you can stay seated.
Yes, sir.
Ms. Dozier, I need you to come around to the witness stand, please. And ask you to raise your right hand and let the clerk place you under oath. Thank you. Have a seat. Mr. Vaughn, she is your witness, so you may approach the podium and question the witness.
Okay.
Would you state your name for the record, please?
Jennifer Nicole Dozier.
Okay. Can you hear her, Your Honor?
Barely.
I'm sorry. I started this 2 days ago and it still hasn't cleared up.
Just pull that microphone to you as close as you can and then try to speak directly into it.
Jennifer Nicole Dozier.
Okay. I can't remember the exact, but the night of this arrest for this case with Officer Jarvis here, do you remember that night?
At Dollar General.
Yes.
Yes.
When I was asked to get out of the car, I know you're saying your area of expertise. Do you believe that I pulled away from her or pushed or gave her?
Not to my knowledge. You stated that you wanted a male officer because you didn't trust female officers.
Okay. Do you, was you ever I'm trying to state this question the right way. Would you ever ask for your driver's license at the scene?
Never.
You don't recall? So you don't know if you, so do you know if she ran your name or?
I'm sure she
to
did.
see if you
They
had-
usually do on like recall.
Okay. Did you have a valid driver's license that night?
Yes.
Okay. I believe the last question I would have, is there any reason that you believe that, that you want to tell the courts of why I don't trust female officers at the words you said?
Yes, because we've had
Pull that microphone towards you closer so that at least we can try to hear you.
that a little better.
Okay.
Yeah, I mean, you said you had female issues with female officers before. I'm sorry, I'm struggling here. You said you had issues with female officers before because of that domestic, and the female officers all came out a long time ago.
Okay. I believe that's all I have for you, Your Honor.
All right. General Bryson, you have any questions?
No, Judge.
Thank you, ma'am. You may step down. You can have a seat in the courtroom, or you may go out in the lobby, or you may leave. Mr. Vaughn, you may call your next witness.
Yes, Your Honor, I don't have any more witnesses.
All right. Now, I'll hear you in argument. This is your motion, so you may argue your motion to suppress.
Can I stay seated here and argue it, Your Honor?
That's fine.
Thank you. This is a motion to squash, to dismiss with prejudice and suppress evidence. Citations under the Fourth Amendment, under the Tennessee Constitution, Article 1, Section 7, and TCA Code 47103A1, and also under the Fifth Amendment for Mirandaization. Oh, this is one case. Okay. Resisting arrest is a charge that my lawful actions does not fit the crime, therefore should the counts be dismissed. State versus Burgess, quoting.
Wait, resisting arrest got dropped yesterday, or not yesterday, the hearing previously. Why are you arguing your motion on resisting arrest? It's not even a charge.
State versus Corridor, concluding that the defendant's not moving and directing obscene language at officers were not sufficient to support a conviction for resisting arrest. Also see Tennessee Attorney General articulating that passive interaction, specifically sitting in a car and refusing to exit, was not resisting. Again, a lack of cooperation in service or process is not a criminal offense, quoting Burgess. The defendant has no legal obligation to facilitate service or process or other cooperation with deputies by accepting service or process, quoting Burgess. The officer had other means of effecting service or process available to them, but elect not to pursue them. His actions did not foreclose the deputy's opportunity to serve and to merely constitute a lack of cooperation with the deputy's chosen method of service. When a detention arises to the level of full-fledged arrest, the Fourth Amendment demands that the seizure be supported by probable cause. So a seizure occurs for probable cause under the Fourth Amendment when the police detains an individual under circumstances where the reasonable person will feel that he or she is not at liberty to leave. Haynes versus Florida. It says, the officer continues detention of the defendant in the back of a locked police car has ripened the investigation, stopping to an arrest, and the officer did not have probable cause to arrest the defendant at the time the seizure was illegal. United States versus Richardson. The police crossed the lines of the investigation into an arrest when they placed a suspect in the police vehicle for questioning ongoing beyond the bounds of a Terry, crossing into an arrest and constitution of seizure. It says, on the night the officer detained me, no force or resistance occurred. With or before the citation mentioned and the Burgess case stating force is physical and obstruction and arrest requires force to be used against the officer. Therefore, the arrest is illegal. Being compelled to accept service after myself and Jennifer stated We do not need your services is unlawful. The escalation should have been the prime intent of the officer of a domestic. The music was up to stop the argument over the birthday cake. The officer could have asked Jennifer to get out of the car to check her for injuries since the concern was for her. These actions with her reaching in the window multiple times, placing me in fear, was just as every other interaction with females responded to domestic, it's bias. State versus Daniels. However, neither the Fourth Amendment nor the Article 1, Section 7 of the Tennessee Constitution limits all contact between police officers and citizens. Instead, the Constitution provisions are designed to prevent arbitrary and oppressive interference with the privacy and security of the individuals. That's quoting D'Angelo. It said the state versus Dowie. Article 1, Section 7 of the Tennessee Constitution is identical in intent and purpose with the Fourth Amendment. Thus, these constitutional protections are implicated only when a police officer interacts with a citizen impermissibly intrudes upon the privacy of the person's security of the citizen. That's my first argument for the dragging on rope. Do you want me to continue with all this, or do you want me to allow the state time to respond?
Well, that is your argument as to the resisting arrest charge?
Yes, sir.
Okay, I'm going to dismiss the resisting arrest charge, which I've already done before we ever began that hearing. So the resisting arrest charge was dismissed voluntarily by the state. So it has no bearing in this argument on this motion, except for whatever arguments you might make about how that impacts the validity of the remaining issues. Any other argument?
Yes, sir.
You have a driving on a revoked license that you're facing, as well as a retaliation for past action. Those are two separate charges, and you have the right to. I would simply point out to you that the resisting arrest charge. Well, I'll wait for you to. I want to let you conclude.
Okay. Also, I want to argue the fact that no exception to catch and release were explored because of the resisting. So, I believe I'm asking. May I ask a question to my sister? Your Honor, I believe I can read a little bit more of this, but I mean, it's already filed into the record. I mean, unless you want me to read it in open court, it's
I
up
don't need
to
you to
you.
read it, but you make the argument. As I've said, all of this that you've argued so far has had to do with resisting arrest.
Correct, Your Honor.
And if you want to address your motion to suppress as to the driving on a revoke or retaliation for past action, then I'll be glad to hear that. But as I've said, I've already dismissed the resisting arrest charge on the state's voluntary motion.
Okay. Well, the rest of these, the arguments I have also stem from the resisting arrest.
That's fine.
And I'm using the resisting arrest as a reason for that we should move for dismissal of the remaining charges. As tainted fruits, let me see.
Fruit of the poisonous tree.
Yes, sir. Let me just go ahead and read some of this. I'm gonna go on and read some of the retaliation right quick.
All right.
All right, for example, Mirandaization is triggered only on custody. So once I was placed in the back of the police car, matter of fact, once I was placed in handcuffs, I was in custody. And Miranda should have fell into a factor. And I was,
Miranda requires that the officer Mirandize you, if you want to say that term, that you be advised of your Miranda rights before any in-custody interrogation.
correct.
Those rights include the right to have an attorney, the right to remain silent, and so forth. There is no statement that's been introduced at this point that where an officer has questioned you or interrogated you while you were in custody, and if they had, then without Mirandizing you, then that the remedy is to exclude that statement.
Yes, sir.
But there is no statement. The statements that have been introduced were voluntary statements made by you, not as a result of questioning. That would therefore, Miranda would not apply.
Actually, it would, Your Honor. There was a question that was asked on the entering of the jail, and I have a case here, it's Travis Lester's versus United States, where it states that any encounter with an officer where they ask you any question is subject to Miranda, because any question that an officer asks can be considered as a listening and an illicit questioning that can be the fruits of a discriminating, I can't find my words, incriminating response. So Miranda would apply in this case, and I have this case here too, if you would like a copy of this, put in the record.
I'm well familiar with the Miranda rights and how they apply.
Let me just read this. I believe this is good to be read in the court. It said, "At no time was I informed of my rights, and I was questioned and answered at the alleged charges. Fear is not a factor when the officer is laughing and instigating the event. There is even a jailer stating, 'You look scared' in the video." It says, "Furthermore, charging me days after," which we already addressed that in the court. Your Honor, before this clearly illegal arrest, the evidence and any statements used to make count 3 retaliation of past act never would have been obtained before that legal arrest. And also, I have some, the fruits of the poisonous tree that stem from that arrest, which is the exclusionary rule, encompasses both the primary evidence obtained as a direct result of the illegal search or seizure and evidence later discovered and found to be derivatives of the illegality, United States versus Anderson. Quoting Serga, "The wrong committed by the Fourth Amendment is fully accomplished by the unlawful search and seizure itself, and excluding the evidence could in no way cure the invasion of the defendant's rights which he has already suffered." That is United States versus Leon. "Instead of seeking for repair of one of the Fourth Amendment right, one violated, the exclusionary rule aims to prevent future violations of the Fourth Amendment by removing the incentive and disregard it. That is Elkins versus United States. And that's all in support of the fruits of the poisonous tree. State versus Blair. "The proper remedy for illegal arrest is the suppression of evidence seized as a result of the arrest, not dismissal of the indictment." It says evidence, State versus Dotson. "Evidence derived from such a search is subject to suppression unless the state demonstrates by preponderance of evidence that the search and seizure was conducted pursuant to an exception of the warrant requirement." And I don't believe that the state will have enough evidence to support that finding, Your Honor. And here's my argument for the retaliation. The state lacks evidence of lack of an intent. They don't have a intent, they can't prove an intent on my behalf that it was actually directed at the officer. They can't prove that there was an intent to do harm to her. There was no proof of none of that. There's no proof that any retaliation even exists. The act wasn't even motivated by retaliation. Just her touching me and telling her to stop touching me, that had nothing to do with her official capacity. The law requires that the retaliation be in response to an official act, testimony, an arrest, a prosecution. That was not the case here, especially when we was questioning her, she said that she gave me over to the custody of the jail. If I wasn't unlawfully committed into the jail facility to begin with, this just wouldn't even been a situation. There wasn't any link between the officer and her official role, lacked the intent. Oh, that's not the argument here. The officer wasn't intimidated, nor was the officer harmed. And furthermore, the arrest wasn't even lawful, so the act of retaliation doesn't even apply. And any responses that came out of me should be counted as emotional and not expressive, nonviolent, nor retaliatory. So my prayer is that the court sees my argument and move to dismiss all of it as tainted fruits stemming from the arrest itself, Your Honor.
All right, General Brusson, you may
Count 3.
respond.
Judge, I'm going to approach this almost backward. The question that I see as almost deciding this is what would actually be suppressed here? So the state is going to trial on 2 counts, driving on revoked. So the evidence that the state would present in that is the officer seeing the defendant driving and the fact that his license is revoked. So no suppression would apply to either of those factors. Okay? The second count, or the second charge that is going to trial is the retaliation for past action, which doesn't have to be actual physical retaliation. The threat of retaliation is what's being alleged here. And to follow the defendant's logic that, let's just say this was a legal arrest, which the state does not agree, but let's just follow that logic. If this was an illegal arrest, by the defendant's logic that his statements should be suppressed as part of a poisonous tree, had he instead chosen to punch the officer in the face and commit an assault, that should be suppressed as well. He is essentially asking for permission to commit new offenses. This is not an interrogation with a confession. It is a new offense. And under case law, even if this were fruit of a poisonous tree, even if we were following down that line, new offenses are not going to be covered by that. They are attenuated from the original incident. And so we just can't go down that road and follow that logic that his new offense doesn't count. Because that's essentially what he's arguing. It doesn't count that I said these threats to her. We don't end up there. That logic doesn't work. So let's go back to this supposed illegal arrest. The officer, as she stated under Pennsylvania v. Mims, had authority to ask him to step out to investigate. Probable cause was determined on 2 different occasions, both by the magistrate and the grand jury, for resisting arrest. Okay? The defendant's behavior, she is asking him to get out. She does have to lay hands on him. Judge, the state chose not to go forward on that charge because there's a difference between beyond a reasonable doubt and probable cause. But the officer had probable cause to make that arrest. And moving forward, she had probable cause to charge him for driving on a revoked license. Now, the question here is not whether or not cite and release should apply, because that's not what the officer was dealing with that day. But looking simply at what the defendant is asking to suppress, none of the applicable legal doctrines would require suppression of those things. The evidence that she saw him driving and his driver's license was revoked, and then he committed a new crime. For those reasons, the state requests that you respectfully deny this motion.
Anything else, Mr. Vaughn?
Yes, sir, rebuttal. Let me hit on the driving on revoke first. The law requires that that once an investigation is ended, that once the reasonable time for an investigation is ended, it should have been ended. It should be. There's video proof that it took up to 29 minutes, which is unreasonable for a stop of that volume, Your Honor. And there wasn't proof of driving on revoked until after the fact. I mean, it's well on into the night. And then there's also discrepancies in the system they're using to say that I'm driving on revoked. It's saying driving on revoked, but multiple times you can look through there and see that the charges are reinstated. And there's also a scene in the video where dispatch is talking to the officer and they're debating on whether my license are actually
Judge, I'm
revoked.
sorry, none of that has come into evidence.
Correct. Sustain the objection. None of that was brought forward in your argument, nor in your evidence, and none of that was played for the court, so I have no evidence to support what you're saying.
Is that not in my motion, Your Honor?
It doesn't matter whether it's in your motion. A hearing such as this is an evidentiary hearing. It's required that you produce proof on every issue to substantiate what you allege in your pleading. Pleadings are nothing more than allegations. So there's nothing in the record today that would support what you're arguing. I sustain the objection.
Okay, all right, and I have to reiterate that for it to be a past act of retaliation, that I have to say something directly to the officer or the victim, Your Honor. And there is not one person or any proof that they can provide that I actually stated something straight directly to anybody. I'm just freely talking. And for it being a new charge, there is no new charge to apply to someone when I'm not talking straight to nobody, and I shouldn't even been placed in a situation to have to even fight a charge. If I wasn't even illegally arrested, I should have been cited and released, if anything.
But you got stupid.
I had one more word that slips my mind, Your Honor. That's all I have now.
Right. In considering your motion to dismiss or to suppress, the court has to view all of the evidence that's been produced here at the hearing. The evidence at this hearing is indicated for Officer Corporal Jevons has testified to as the reasons for her initiating the stop of this vehicle were to investigate a domestic violence situation. She approached the vehicle and began speaking with you. She asked you to step out, or the defendant to step out. The defendant refused after repeated requests. Why is that important? Because the court is well aware of the fact that there is a greater risk of violence or threat of harm to law enforcement in response to domestic violence cases than many other kinds of cases. But an officer who is investigating a scene has a right to request that a person step out of the vehicle. Refusing to step out of the vehicle, and according to what we saw, was what you could consider to be some sort of forceful resisting. The argument that there is no valid charge of resisting arrest because it's, of the circumstances, and therefore the fruit of the poisonous tree, so to speak, would apply, implies that there was, or assumes that there was an illegal arrest for that. 39-16-602 of the Tennessee Code defines resisting stop, frisk, halt, arrest, or search. And that, under subsection A, says it is an offense for a person to intentionally prevent or obstruct anyone known to be a person, to the person to be a law enforcement officer or anyone acting in a law enforcement officer's presence and at the officer's direction from effecting a stop, frisk, halt, arrest, or search of any person, including the defendant, by using force against the law enforcement officer or another. Subsection B, except as provided in section 39, TCA 39-11-611, it is no defense to prosecution under this section that the stop, frisk, halt, arrest, or search was unlawful. So it basically says that can be. Now, I understand the argument being made that you really didn't do much to resist, according to what you were saying. But there's sufficient case law that would support a finding of guilt, and that's really not the issue, because what we're dealing with is probable cause. Is there probable cause for an arrest? Don't confuse the fact that there is a lower standard for probable cause to make an arrest than there is for a conviction beyond a reasonable doubt, which is what you're arguing. Evidence was sufficient to convict the defendant of resisting arrest because the defendant ignored officers' orders to come out from underneath the vehicle and had to be dragged out, and the defendant then refused to place his arms behind his back so that he could be handcuffed, and the defendant struggled with the arresting officers before his investigator was able to place handcuffs on him. State versus Baker, a 2019 Court of Criminal Appeals decision. The application for appeal to the Supreme Court was denied, and that's found at Lexus at 2019 Tennessee Lexus 484, September 20th, 2019. So that was supporting a finding beyond a reasonable doubt of sufficient proof for resisting arrest. In this case, the court is only concerned with whether there was probable cause for the issuance of the arrest, because if there was probable cause for the issuance of the arrest for resisting arrest, which clearly by this court's finding there was, then the argument you make about the fruit of the poisonous tree is actually irrelevant because it does not apply. But in any event, the officer had probable cause to stop the vehicle, had probable cause to interrogate the passengers in the vehicle during an investigation for domestic violence. Why require the driver to step out? Because under the circumstances with the type of charge, very easily that a person could have driven away and fled the scene with the victim of the domestic violence in the vehicle with him. Those are just concerns that the court is aware of that could have applied. They ask a person to step out of the vehicle sometimes for officer safety. There is nothing illegal about that. The resisting statute makes it clear that resisting an officer's directions to step out of the vehicle where you have to be dragged out make it a part of the statute. So even though the state is elected not to proceed on that charge, the fact of the matter is that there was probable cause for the arrest on that charge, and therefore, even if that charge was dismissed, there was probable cause that existed for them to initiate an arrest, in this court's opinion. As to the driving or revoke charge and the argument about cite and release, yeah, if he had stepped out of the vehicle and offered his driver's license to the vehicle without resisting, then he could have been cited and released at that point. The officer had probable cause to stop him and check his license and to check the circumstances during an investigation of the domestic violence, and could have checked his driver's license and allowed him to be cited and released. His actions on that scene, on that particular moment, are the very reason why that did not occur. As to the retaliation charge, this court disagrees with the interpretation that Mr. Vaughn makes of retaliation. 39-16-510 of the Tennessee Code provides for retaliation for past action. And it says, a person commits the offense of retaliation for past action who harms or threatens to harm a witness at an official proceeding, a judge, a district attorney general, an assistant district attorney general, an employee of the district attorney general, or a law enforcement officer, clerk, employee of a clerk, a juror or former juror or family member of any such person by any unlawful act of retaliation for anything the witness, judge, district attorney general, assistant district attorney general, employee of the district attorney general, or law enforcement officer, clerk, employee of the clerk, or a juror did in official capacity, and so forth. The offense of retaliation for past action shall not apply to an employee of a clerk who harms or threatens to harm the clerk, and that has nothing to do with yours. So the statements that have been introduced at this hearing the other day and today are that the defendant made the statement, got some bullets for all of you, after he was at the jail and was upset about being arrested. The other testimony today, as he walked into the jail with Corporal Javins, was, I'm a threat for a reason. And then it was also testified that as he was trying to take the handcuffs off and be at the jail, that he made the statement, fuck no, I'm going to beat that bitch. This court is of the opinion that all of such statements constitute sufficient probable cause and sufficient evidence for the matter to go to the jury on a charge of retaliation for past action. Therefore, the defendant's motion to suppress, dismiss with prejudice as to docket number 336 is dismissed. Now, we have other motions. Those motions are not applicable to the case that's set for trial next week. I will allow Mr. Spratt, if you want to have a moment to talk to your client about arguing those motions today. They would be motions to dismiss as to the other charges. His other charges include docket number 462, 2021-462, an aggravated assault while displaying a weapon, reckless endangerment with a deadly weapon involved in counts 7 and 8. Counts 1 through 6 are aggravated assault. Counts 7 and 8 are reckless endangerment with a deadly weapon. And count 9 is possession of a firearm by a convicted felon. And the additional charge, indictment number 337, 2022-337, he is charged with simple assault, false imprisonment, disorderly conduct, and public intoxication. And then with 2024 CR 142, he's charged with failure to appear. So the question becomes, is the state able to produce the witnesses necessary for a motion to suppress or dismiss as to these other charges? Is your microphone on?
Judge, on 462, I need about 3 different officers. And one is in training, one is driving a truck and might be available by Zoom, but my preference would be just to reset that motion to hear at another date when they can all be present in person.
Well, we have later this month, of course, this trial is set for Thursday.
Objection, Your Honor.
Pardon?
Objection. Availability of witnesses is not a reason for rescheduling.
That's in your opinion. This court's opinion is we've heard the motions today that are applicable to your trial set for Thursday of next week. The fact that we have other motions that are filed that are for cases that are not yet set for trial, this court is of the opinion it is not prejudicial to reset those motions for another day. I'm inclined to set them on the 29th if you can get your witnesses.
Excuse me, Your Honor, we're still under the Fast and Speedy Trial Act. I put a motion for Fast and Speedy Trial. Part of the act states that that is not a reason for a continuance.
I don't have a trial date on your additional charges, but we will certainly assign you a trial date. What I'm suggesting is that you have a trial coming next Thursday on the first of these cases. We can't try all of those cases under the same jury pool. For your detriment, it would be detrimental to you for us to bring a jury in out of the jury pool, select a jury, try the cases that we've talked about today, then turn around the next day, and that same group of people who now know that, the evidence regarding that charge are then asked to sit in judgment of you. Let me finish. Who are asked to sit in judgment of you. I can't trot in a different jury panel for cases, multiple cases, to try them back to back to back. I'm trying the one that the state has elected to go first. We will then select a speedy trial date for your other charges as soon as we finish trying that one. I would like to see how soon we can set it. And if we can go ahead and set it for a trial either this month or next month, if you can get your witnesses in. Well, this month would require a different jury pool. For that reason, it would have to be next month.
So we're setting a continuance for her witnesses, correct?
A continuance on your motions.
Yeah, that's the same argument. It ain't got nothing to do with the trial I'm talking about. The continuance just for the witnesses to be present is what I'm arguing.
And what detriment to you is there for continuance of the hearing on the motions you filed when your cases that those apply to are not set for trial? How does that prejudice you?
Well, my witness is here today, and it just...
She's under a subpoena to reappear.
I understand that, Your Honor, but for her to keep on coming out of her way, I don't even know if that's possible.
Well, she's under a subpoena, so it is possible she will have to appear or she'll be in contempt of court.
Is there a way for her to appear Zoom if need be, Your Honor?
No, not under the circumstances. Well, if for a motion hearing, we might be able to do it by Zoom, yes.
Yes, that's what I'm asking, because the officer's allowed to do it. My witness should be able to, too.
I think if I allow an officer to do it, she'd have to be allowed to do it as well. And we'll be happy to set that up for her. If she's nodding, that's what she'd like to do, so we just need to make sure that she gives Mr. Spratt her information so that whenever these motions are set. I'm inclined to set the motions on the 29th General, is there any reason you can't get your witnesses together on the motion for the 29th in the afternoon
Of this month, Your Honor,
of this month?
there's a
September
highly
20
probability I'll be in Decatur.
Pardon?
There's a high probability I'll be in Decatur.
High probability you'll be in Decatur.
Judge, he has a circuit court date in Decatur on September the 30th. I don't know when they transport, but that's
Right.
what he's expressing.
Oh, gee, another case. More charges. Go figure.
How certain are we that Jimmy Reader PCR is going to go? There's a possibility that we could do the motions the first part of October, but I won't know that until after Tuesday of next week. So after Tuesday, the 23rd, I should be able to tell you if we can use the first, second, or the 1st or 2nd of October for the hearing on the motions. What do you have, General, on those days?
Judge, I would be available that day, and I should be able to reach out to witnesses for motions that day.
Then let me determine on Tuesday, after Tuesday of next week, I can tell you if we can have your motions heard as quickly as the 1st or 2nd of October. Right?
Will that be by, mail or?
Well, I'm going to have to let Mr. Spratt know first, and then we can notify you by mail if that's necessary. I want to get word to you as quickly as possible.
Okay.
About the order appointing me. Some of this stuff, I'm not sure that I have the order appointing me, but I don't think I'm allowed to be compensated at all for this.
And we'll enter an order not pro tunc because I'm almost certain I saw an order appointing you in this file.
And Your Honor, the way I read the Supreme Court rule is that Mr. Vaughn being the pro se first chair, that the Supreme Court won't allow for co-counsel. So the order is conflicting there. There, I believe I did at one point see an order that appointed me as counsel, but I don't think the court ever announced that.
Yeah.
Mr. Flanagan, Mr. Vaughn was here on the failure to appear that was ultimately dismissed. And the court, if I'm not mistaken, appointed me as elbow counsel that day. And then Madam Clerk's office sent a standard appointment order that I never understood to have any effect. I never understood that to have the effect of appointing me. I don't think the Supreme Court's rules allow me as second chair to be compensated in Class E, D, C, or even B felonies. I think it requires like a death penalty case or a first-degree murder case for co-counsel to be appointed.
You may be right.
And that being the case, I have volunteered since Your Honor's ruling, and I will be filing a motion in another case for Monday to have me designated as lead counsel under that rule in Ms. Stephanie Lowe's stead. But that being said, if I'm not able to be here at some of these dates, I've have quite a bit going on with transitioning into my solo practice and closing out some cases, and I have civil cases and cases everywhere. So I'm not trying to withdraw from Mr. Vaughn, but just say in the hypothetical, in the past when Mr. Baker and I have had cases, sometimes he might be here to argue them, sometimes I might be, and I don't mind coordinating a witness for him. It's just that I can't, I'm under an order that doesn't compensate me, ostensibly in violation of the 13th Amendment. I like Mr. Vaughn, and I don't mind helping him at all, but
I understand. Let me review the file and we'll determine that. Obviously, we have a trial next week, and it's my understanding you're willing to assist him in that trial.
I am willing to assist him in that trial, yes,
So
sir.
we'll determine the remaining charges at that point.
Yes, sir.
And the law is that where Mr. Vaughn has elected to represent himself, that the appointment of advisory or elbow counsel is completely within the court's discretion. He's not entitled to it. It's within the court's discretion. Frankly, reading Mr. Vaughn's pleadings that he has filed, he demonstrates a level of legal expertise that is unusual for a pro se defendant. And therefore, I'm not really as concerned now, having read through all of his pleadings as I was initially, that he's in need of advisory counsel. He seems to be very competent to raise all of the issues he wants to raise, and for that reason, it may be necessary to relieve you if you're not being compensated from representing him further beyond the trial next week.
Yes, sir. I do think he would need, I'm not volunteering per se, but I do think it would be beneficial for him to at least go through his first jury trial before we.
Once he has gone through the first jury trial with you, then the remaining jury trials, he would at least have some experience. So. All right, then we'll.
At that time, I would request for another elbow counsel if possible, Your Honor.
Now, that's the thing, as I just explained, if you elect to represent yourself, you don't have the right or entitlement to elbow counsel. I have the discretion, within my discretion, to appoint someone to help you. Now that you have filed all of these pleadings, and I've seen that you have a level of expertise in raising all of your issues, I don't find that you are necessarily entitled to have elbow counsel. You're representing yourself. That comes with the obligation that you be prepared to do everything that you're supposed to do. So Mr. Spratt will stay with you through this next trial, but I do not intend to appoint elbow counsel to help you with the remaining charges.
I object to that, Your Honor.
I understand you object to
The
it.
Sixth Amendment, I believe I'm calling the right amendment, counsel and as I see fit.
So are you wanting to have an attorney to
I'm
represent you?
still wanting to represent myself. I want to stay lead seat, but with assistance.
And as you heard me state, the Supreme Court's rules are that elbow counsel is advisory in nature only and completely within the discretion of the court. And to appoint an attorney who would have to then stay with you at no compensation, this court is not entitled to do that. You can hire your own lawyer if you want to. This court is not going to appoint an additional elbow counsel.
Oh, the judge just punked him. Absolutely punked him. Oh, he demonstrates a level of expertise rarely seen by defendants. Yeah, BS.
So Mr. Spratt, we'll stay with you. We will see you all on Thursday, if not before. So I'll let you know after Tuesday whether or not the October date will apply, although Mr. Spratt has indicated he will no longer be able to continue. So we're going to break for lunch, and that will conclude this hearing today, and the remaining issues will have to be scheduled for a future hearing. Make sure that that the witness that was here under Ms. Dozier has given the proper contact information, and we'll go from there.
Oh, that was so much fun. Yes, yes. Yeah, he doesn't want an attorney. He just wants an attorney. My gosh, Bandit. You made such a big mess over here between chasing your ball and having to have your treats and oh my. Put that over there for the other cats. You just didn't know what you wanted. She her favorite toy now is this. It's a little fuzzball made out of Billy's fur. I just rolled it into a ball and yeah, she loves playing with Billy. Well, she tries. Billy doesn't love her. But I just had the ball sitting here. He sheds a lot, and I brushed him last night. So when I got done brushing him, I just rolled it into a ball. I didn't think much of it, and she went nuts. Oh, well, the good news is there's more to come. We still have his trial coming. And that's set for Friday. Oh, he certainly did. He certainly did. I'm sure it's Friday. I think it was, yeah, it's got to be Friday, the 25th. No, it's Thursday. Maybe it's Thursday and Friday. I know. I'm looking forward to it. Y'all have to give me the day to edit it. So I might have to do the same thing I did today, where like I'll edit it the night that that I would go live, because Judge Wolf typically runs pretty late, you know, and so if I've got to wait out the full 6 hours and then start editing, yeah, it's going to take me a bit. and I promise you, you don't want me to just live stream it raw, because I'll put it this way: the one hearing alone was 2 hours and 49 minutes, and after I edited it, it was down to an hour. There was that much space and time gaps and breaks and recesses, and yeah, when the attorney and he went out in the hallway, yeah, so one hearing was like 2 hours and one was an hour, or was 2 hours and 40 minutes, and all said and done it was 2 hours total. So I cut a lot of dead air out. So you don't want me streaming it live. It needs editing. Plus the audio issues. I had to enhance audio in multiple places. So I don't want to live stream it and have it just be a 6 hours of us sitting through 4 hours of nonsensical silence, you know? Oh, that's what he's banking on. 100%. He has no case. He was when the and it had to have been a tactical move for prosecution to drop the resisting arrest charge. That had to have been purely tactical, and it worked. It all he had to argue on was that resisting arrest, and he was so confident that if he got that resisting arrest charge thrown out as an unlawful arrest, then the other charges would just fall away. Well, they took it out of the equation, and the other charge stuck, and he didn't know what to do with that. And apparently neither did his co-counsel, because that was terrible. That cross was awful. I am honestly surprised that prosecution didn't object to badgering the witness with the elbow counsel going after her like that, repeatedly asking the exact same question. And what they don't seem to understand is it's not you ask the question until you get the answer you want. You ask the question, and whatever answer the person on the witness stand gives you, that's their answer. That's their testimony. It is not up to the witness to make your case for you. That's not how that works. Oh my gosh. Hello, Chris Van Allen. Oh, sweetie. We should let her know it's all done. Hold on one second. Chris. It's all done, hon. Oh, well, and the judge, okay, for the attorney to be doing it and not legally be allowed to be compensated for it, the judge made the absolute right call to say, you know, it's up to the discretion of the court whether you are appointed co-counsel or not. And quite frankly, if you choose to represent yourself as head chair, that is On you. Hi, Bandit. Bandit's my co-counsel, my co-host, my baby. Look at that grump face. Look at that grump face. Go grumpy. You still grump. Oh, he did not. His case is still going to trial on Friday or Thursday. I will double check. It is still going to trial this week. So we will, I will try to do that one as a day stream also. As I was telling the chat, I'll edit it the night that I would normally be streaming it, and then I'll stream it the following day. So be on the lookout. That way you can join us again. Oh. I don't know. I don't know if I might. I don't know if I can hold my composure through it. I mean, that one still hurts. That was hard. And I'm still, it's I'm still struggling with that. Oh, thank you so much. I appreciate that. I do the live streams, and then I chop the live streams up and remove commentary for people who don't want to sit through, multiple hour lives. And I do the individual cases as just the cases only and post them as videos. I probably won't with this one just because it is a 2-hour hearing. But that's like, I typically do a lot shorter cases. And I try to keep the videos around, 10 to 20 minutes in length. So that way people can watch them on their lunch breaks and stuff like that. So you'll see what's called replay crew mini videos. And that's what those are. If you don't want to sit through an entire live stream and listen to me gab, that's what the replay crew mini videos are for. I don't know, sweetie. I don't know. But that's why we invented the Discord accounts, because YouTube doesn't like me. I'm not a big channel, guys. I've got just over 5,000 members. I'm not this huge content creator that, YouTube thinks is worthy of pushing me out. It's just little old me over here. Maybe try undoing the notification and redoing it. I don't know. Mr. Allen. Mr. Allen in Judge Simpson's court? Is that what you mean? Discord is a social media platform. It was originally designed for gamers to be able to game and interact at the same time. It then transitioned into just a general social media for anyone. Now, Discord is a wild place, so you have to be very careful where you venture off of it. It can get pretty scourge of the earthy in some places, but there are some very wholesome channels. There's almost every content creator or show or anything has a Discord just for people to go in and chat, share pictures, and interact within their own community. It's essentially just another community place. But I posted the Discord link for my channel. So anybody who wants to join it is right there. Yes. Only my personal account. I don't, and it's the same personal account I've had all my life. So, or, well, as long as Facebook's been around, and, I don't really use it for channel stuff, because my family, my friends, well, I don't really have a whole lot of that, but, you guys are the only ones that are like really into this stuff. So, if I were to start posting it, like on my personal page, which I don't post anything on, I mean, who knows? They wouldn't be into it. Nobody would care. Okay, guys, I'm going to take off. I do not know if I will be back tonight for the regular stream. I mean, it's almost 8 o'clock and I haven't even started editing for tonight. Well, hey, Bandit Baby. Oh, I did grab, when I got up to go potty, I grabbed the Moulin to show you. So this is the one that I ordered from Walmart. So it says it supports healthy respiratory function, healthy immune system, and normal bronchial health. So right now it's the prednisone doing all the work, but hopefully this will make a change too. You can already feel my voice getting warbly. I don't like it. I don't like it at all. Oh no. See? Everybody, it's an everybody thing. Heck, I can't even on Credence and Mikey's channel, I can't even super chat them. I've been in contact with YouTube over it because it's the only channel that I cannot I comment. No one sees my comments. It's like I'm shadow banned on their channel, but they didn't do it because Credence and Mikey, I mean, they're my friends. I talk to, okay, well, I consider them my friends. I talk to them, we message in Discord and stuff. And I sent them screenshots of what was going on. And they sent me screenshots back showing, no, I'm not blocked. I'm not hidden. There should be no reason for it. But no, YouTube will not allow me to super chat them or anything. I went on there and I was trying to buy memberships for people and gift them, and it wouldn't allow me. And that's insanely frustrating. It makes me so mad because they are really awesome guys, and I absolutely adore them. And I wanted to support their channel and support the community, and it just, YouTube won't let me. So emails are out and probably will never be resolved because that's how it goes. Okay, guys, thank you so much for coming out and hanging out with me and watching me play with Bandit for a little while. You guys are amazing. I love you so much. Be safe, be well, sleep sweet, and much love.